issue where it talks about the jury can reasonably infer things. However, to the extent we're going to observe the fact that that is not to prejudice the jury that will be selected in any way, or after they are selected, we are going to observe that in accordance with the law. The jurors, as previously discussed, prospective jurors are going to be given numbers. While they are in this room, we are only going to refer to them by their number. The parties will have lists where there will be names and also address information that will correspond with the numbers. If you need to use the actual name of the prospective juror, please do so only in the room when we are doing the examination of the individual jurors. As far as telling the jurors that go through the individual screening process when to report back, I was anticipating telling them to come back on Thursday afternoon. By that point, I believe for this morning, this afternoon, Wednesday morning, Wednesday afternoon, and potentially also Thursday morning, we will have a suitable number of jurors at that point to move into group voir dire. As far as opening statements, and I believe before when we were discussing this in the context of whether we would have available to us Labor Day or need to work essentially non-standard days, my goal is to have a ruling for you on all outstanding motions before we actually move into the group voir dire process. Obviously, I'm not poking you, but hearing motions up through yesterday has impeded my ability to review the authority you've presented and actually prepare a thoughtful ruling. Until I can do so, we will still remain on track for getting to group voir dire, but if I don't get the ruling to you either today or tomorrow, by latest, you will have it before it's actually time to start the group voir dire. Once we have selected a jury, if we are successful, depending on the hour, I believe we will need to move into going into opening statements. Once you have your ruling in hand, you will be able to tailor your openings as need be. I believe for the most part, the only outstanding rulings that remain at this point are the motion to suppress and the portions of the motion in limine that have not been ruled on. Are there any questions concerning these matters?
This time around.
Very well. I believe downstairs, Judge Ashenofi Richardson is qualifying the jurors. Once they have been qualified by her, they will be brought upstairs, handed their numbers. I will ensure that anyone who needs to be excused for statutory reasons is excused before we move into the individual process. Also this morning, after going through anyone who needs to be excused who was not previously, I will give them their instructions concerning not talking to each other, discussing the case, or looking at any materials that are related to the case. I believe the reading material that's here in the room. Oh, okay. Yes, provided for our prospective jurors some travel magazines, so they have something to look at while they are waiting to be screened. From there, again, they have their phones, they have their reading material. Other than that, the deputies are to ensure that no one is speaking to each other, and certainly no one in any way is trying to engage with content about the case. Does either party have anything they need to raise concerning this?
But can we go back to Julian and I have a difference of understanding of what you said about how jury selection was going to proceed?
Go ahead.
Start individual voir dire today, and the ones that are coming back are calling come back Thursday afternoon.
Yes.
I think that's too long.
In terms of what?
I don't think it'll take that long to do individual voir dire. To start.
If we need to tell them to adjust when they need to report on Thursday, that can be easily accomplished. But the goal being, if we need to go through at least 5 rounds of individual screening, before we get to 100 or more, that would be the point of telling them to return Thursday afternoon.
But it could be possible to start group questions Thursday morning.
Once we've hit 100 that have gone through the screening process, then it could be as soon as 3 groups of 50, but hard for me to guess on that aspect. Does everyone understand? What's up? Okay. All right. For the timing of the trial that we will discuss with the jurors and going through the aspect of hardship, again, my expectation is to tell them, including the process of selecting the jury today, that we may need their service for up to 3 weeks. If this changes in any way, obviously we will have to let them know. But we will also have our 3 alternates in addition to our 12 jurors. I think by statute and rule, it's clear this is a 10-strike, 12-jury case. Does anyone have an understanding of the contrary?
No, Your Honor.
No, Your Honor.
Very well. If either party needs to seek additional peremptories, as long as the process that is identified by cases are followed, with that, a proper ruling will be made. Does anyone have any questions as to that?
No, sir.
Right. We will wait then for our jurors to arrive so we can go ahead and get everyone properly seated in the courtroom this morning. Other than the camera operator, I'm going to need everyone who's seated on my left, your right of this room to come over and take the seats that are over on the right side, so that way we are filling these benches with prospective jurors only. For the members of the media that are present, again, I believe we've already gone over this, but no faces are to be disseminated concerning the prospective jurors or the selected jurors. No names, nothing that can identify them. As far as once a jury is selected, of course, you can report on the biographical breakdown, male, female, what their occupations are, things of that nature. But as far as anything that could specifically identify them, that is where the line will be drawn.
I don't know. I think so. Yeah, I said we're waiting for the jurors.
All right. When you get an update from downstairs, please let us know when the jurors are coming up. We'll get them seated and then we'll get started. We'll have a brief recess until we have our jurors upstairs.
I assume it's going to be very simple.
judge sit 3 alternates. Surely we can bring another chair. Yeah. Yeah, I'm sure he's gonna roll in a chair.
This is probably. So.
Or you can just, then I won't have a set, right?
No, I can,
Probably be okay.
depends on,
He does have a set.
it's there, I can't.
So there's a chance we could all have.
Chad, so this,
Okay. We'll make it work.
Well, yeah, that's.
Those first two votes.
Well, I don't know.
Assuming probably. Yeah, but. He just. You already. Right, but I think this is so bad. She's gonna come out. Okay. Okay. That's all it.
It's breaking nobody's job.
I'm pretty sure that's the mute. I'm sure. All right, can someone please text Jason and tell me if you can hear us? Yeah.
Jurors, respective jurors, I should say, are on their way up now. Do they meet the criteria by statute? All right, bring them up. I'll just address them when I get here. Yeah.
Ron,
Yes, sir.
just wanted to discuss the statement of the case. I was operator of the group that you were just going to be reading the same one that went straight up this trial.
Just the indictment that has actually been filed, yes.
Well, I'm referring to the statement of the case of the jurors. Think about what question you're going to be asking them about.
Oh, yes, go ahead.
Might be easier if I just bring the transcript up.
It's fine.
That's the end.
Sure. That's it. Just the questions that are highlighted.
And the statement of the case started on the prior page. I don't.
You're just asking for this to be read?
Yes, sir.
Okay. Trying to see when this was given.
This was in Charlie's.
Right, right. But at the point in which it was given. Does someone have this portion printed out? Please. Did they not come up with the rest of the group? Okay. Okay. Are they first 14 in there, everyone else over there?
Please rise for our Prosecutors. Good morning. Juror 1, this way, please. Good morning. You're going to go all the way up here. You're going to go all the way down to this. Yes, sir. Good morning. Juror 2, right here, please. Juror 3. Okay. Thank you. 3. Just skip that seat right there next to that gentleman. You will sit down. 4. Right here. Yes, sir. Please. 4, 5, 6, right here, please. Good morning. 4, 5, 6. Good morning. 7, 8. Morning. Good morning. So you're gonna start the new roll all the way down for me, please. 9. Good morning. Right here. All the way through here, right here.
Okay. Sorry, may I have a seat?
No, not a problem. You're gonna go all the way around. Good morning. Right here. Good morning. All the way through here, please.
At least these are a little more comfortable
Right
than the
here.
others. Probably why they suggested grabbing the jacket.
Good morning. Seats right there. Yes.
Want to use this to warm up for the moment? At least helps.
Sir, if you can remain quiet for right now,
I do apologize.
thank you. You can be seated. Once the bailiffs have directed you to your chairs, you may be seated. We still waiting for anyone outside?
About 10, 11 more to go.
Okay.
Two and 15 on this.
Okay. Everyone can be seated. Patricia, once numbers 2 and 15 have been located, they're just to be seated in the back. We're going to move forward with what we have right now. Good morning, ladies and gentlemen.
Good morning.
Okay, not great. Let's start again. I'm giving you a proper greeting, looking you in your eyes. All I'm asking back from you is for the same. Good morning, ladies and gentlemen.
Good morning.
There we go. I'm Stephen Everett, one of your circuit judges for the Felony Criminal Division here in Leon County. You have been summoned here today as prospective jurors in the case of the state of Florida versus Donna Adelson. This is case number 2023 CF 3226. This is a criminal case. The state has charged Mrs. Adelson with the crimes of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. You will notice at times during this jury selection process today that I will be reading to you. It is not that I do not wish to have a normal or free-flowing conversation, but rather any explanation that you receive on the law during this process must be uniform and it must be specific according to the Florida Supreme Court. Is the state ready to select a jury in this matter?
Yes, Your Honor.
Is the defense ready to proceed as well?
Yes, Your Honor.
And for the record, I'm noting that Mrs. Adelson is present in the courtroom with her counsel. I believe downstairs a few minutes ago, you spoke with Judge Ashenofi Richardson, where she went through the qualification process with you concerning who is actually eligible to serve as a juror in the state of Florida. What I'm going to do, just to make sure that anyone at this point would otherwise qualify to be excused by statute, I'm just going to confirm this information. By a show of hands, is everyone who has been brought up this morning at least 18 years of age or older? Please raise your hands. For the record, all prospective jurors have answered in the affirmative by raising their hand. Are each of you citizens of the United States of America and residents of Leon County, Florida? Please raise your hands if this is so. Again, for the record, the prospective jurors have raised their hands in the affirmative. Are all of you residents of Leon County? Please raise your hand if this is true. Again, the prospective jurors have raised their hands. Thank you. Do each of you possess a driver's license or identification card that's been issued by the Department of Highway Safety and Motor Vehicles, or have you executed an affidavit as to your eligibility to serve as a juror? Please raise your hands. Once again, for the record, the prospective jurors have raised their hands in the affirmative. The next series of questions are basically just going to deal with whether anyone should be excused at this point or is ineligible to serve. Has anyone been previously convicted in a state or federal court of any felony crime or a crime of dishonesty, and you have not had your rights restored to you? If this describes your situation, please raise your hand. For the record, none of the prospective jurors have raised their hands. Are any of you at this time under current prosecution for any crime, either in a state or a federal court? Please raise your hands if this describes your situation. Once again, for the record, none of the prospective jurors have raised their hands. As to matters in which you can be excused by law, is any person here a sworn federal, state, or local law enforcement officer or investigative personnel? No hands have been raised in response to the court's questions. Is anyone an expecting mother or a parent responsible for the full-time care of a child under 6 years of age? All right. Sir, if that is, please form a line and I will deal with you momentarily just in the middle. Is anyone present 70 years of age or older? No hands have been raised in response to this question. Has anyone performed state jury service within the last year? And by last year, what I'm referring to would be August 19th, 2024 to today. No hands have been raised in response to that question. Is anyone responsible for the full-time care of a person with a physical or mental incapacity who is incapable of caring for themselves, and your presence will create a hardship? No one has responded in the affirmative to that question. Is anyone a full-time student between the ages of 18 and 21 years of age who is attending a high school, state university, private post-secondary educational institution, Florida college system institution, or career center? Right, if you please can stand behind the gentleman in the aisle. I believe we also have one new one by statute. Has anyone given birth within the 6 months before the reporting date on your summons, and you are seeking to be excused for that reason? No hands have been raised in response. Right, one by one, if you please can come forward, and I will address the issue in which you responded to your questions, or to the court's questions, I should say. If the attorneys wish to listen to the court's conversation with the prospective juror, do This might sound funny in courtroom, standing with the microphones everywhere, and we try to keep the distance as far as possible.
Hey everyone, it's the COE here. Just want to remind everyone that Joel is on his way to Tallahassee. He'll be live from Tallahassee tonight, so he won't be giving us any inside information in terms of the courtroom and jurors today, but he will be doing that tomorrow. And again, we'll be here all day, so please remember to hit like, subscribe if you're new, and we'll try to pull up some comments here and there, but if there's anything visually, I don't want to block it. But yeah, thanks so much. We appreciate all of you guys, and we're just going to watch this all day. Thanks so much.
All right, now that we've settled the issues of who is eligible to serve and actually remain, we are going to proceed with the process this morning. The first thing that we are going to do is to discuss what you may know about this case, if you've heard anything about it at all. This case has received some publicity, and there also was a related case that took place almost 2 years ago. This process is going to be handled individually because you will not need to know what others may already know concerning this matter. However, before we start that questioning, I am going to give you some very important instructions. Many of you have cell phones, computers, and other electronic devices with you. Even though you have not yet been selected as a juror in this case, there are some rules that you must follow about using your cell phones, electronic devices, and computers from this point moving forward. You must not use your phones or devices to search the internet or to find out anything that is related to this case. Between now and when you have actually been discharged from jury selection or jury duty, you must not provide or receive any information about your jury service to anyone, including friends, coworkers, and family members. You may tell those who need to know where you are that you have been called for jury duty. If you are picked for the jury, you may tell people that you have been selected for the jury and how long the case may take. However, you must not give anyone any information about the case itself or the people that are involved in this case. You must also warn people not to try to say anything to you or write to you about your jury service or the case itself. This includes face-to-face interactions, phone or computer communications. In this age of electronic communication, I want to stress to you that you must not use electronic devices or computers to talk about this case. This would include tweeting, texting, blogging, emailing, posting information on a website or chat room, or through any other means at all. Do not send or accept any messages, including email and text messages about your jury service. You must not disclose your thoughts about your jury service or ask for any advice on how to decide the case. Further, you must not read nor listen to any news accounts about the case until you have been excused in this matter. Please avoid the newspaper and television broadcast, particularly the local news stations. Also, avoid any social media or any internet news sites concerning this matter as well. Mr. Zellman, if you still have the statement of case on your computer, I will just read it from that. You may. I'm going to read to you at this time a statement of the case that has been agreed upon by the parties. On July 18th, 2014, FSU College of Law professor Dan Markel was shot while seated in his car. This happened in the driveway of Markel's home on Trescott Drive in the Benton Hills neighborhood. The killers traveled to Tallahassee from Miami to commit the murder in a rented silver green color Prius. The defendant and alleged conspirator in this murder was the former mother-in-law of Dan Markel. She has entered a plea of not guilty. The statement of the case that I have just read to you is not evidence, and it's not to be considered by you as evidence or any proof of guilt. You must not be influenced by this statement. It is merely informing you of the accusation that has been made by the state against the defendant. Before we speak with you individually and privately about this case, some of you may be excused. Mr. Zellman, you can take it. I'm also going to read to you at this time the material part of the indictment that has been filed against the defendant. Once again, the indictment is not evidence, and it's not to be considered as evidence or any proof of guilt. You must not be influenced by the fact that an indictment has been filed. In this case, it is merely a formal method by which the state makes an accusation against the defendant. It is alleged in count 1 that on or about July 18, 2014, Donna S. Adelson in the county, Leon, and state of Florida did unlawfully kill a human being, Daniel Markel, by shooting with a firearm, and the killing was perpetrated from or with a premeditated design or intent to effect the death of Daniel Markel, contrary to the Florida statutes. Count 2. Beginning in 2013 and until October 1st of 2016, Donna S. Adelson in the county of Leon and state of Florida did agree, conspire, combine, or confederate with Charles Adelson and or Catherine McBanawa and or other persons to commit first-degree murder, contrary to the Florida statutes. Count 3. It is alleged that beginning in 2013 and until October 1st of 2016, Donna S. Adelson in the county of Leon and state of Florida did solicit another to commit first-degree murder, and in the course of such solicitation, commanded, encouraged, hired, or requested the person, Charles Adelson and or Catherine McBanawa, and or other persons to engage in specific conduct which would constitute first-degree murder, which resulted in the death of Daniel Markel, contrary to the Florida statutes. I believe I said this before, but we are now going to speak with each of you individually and privately about this matter. Some of you may be excused during this process. The rest of you will remain to participate in the next phase of the jury selection process. Individual voir dire is time consuming, but will go a lot smoother if you are prepared to tell us what we need to know. The basic questions that you will be asked are the following. Number one, what do you know about this case? Number two, what sources have you obtained this knowledge from? Number three, based on what you know, do you have an opinion about Mrs. Adelson's guilt or innocence? Number four, can you set aside your present knowledge, disregard it, and render a verdict solely on the evidence presented in the courtroom? Can you be fair and impartial? Number five, do you have any reason that you cannot serve on this jury for potentially up to 3 weeks? It will save us all a lot of time if you think about these 5 questions and you are prepared to give a prompt answer when you are called back. We are going to discuss one thing with you individually, specifically as it relates to the hardship of serving on this jury. We expect the jury selection process to take until Thursday of this week. After that process is complete, we expect the trial to start on Friday and potentially go for 2 weeks after that. All in total, we expect the proceedings from today may take up to 3 weeks. We understand that is a burden for anyone to serve for that length of time. However, we cannot make our system of justice work unless we have good people that are willing to do their civic duty as jurors. Similar to military service, we will have to call on our citizens at times to make sacrifices. Jury duty is one of those times. You will probably never be called upon again for something of this nature to serve in a lengthy trial. I understand for some of you, this may not be possible under the circumstances. To give you a little more information about what this will involve, you are not going to be sequestered during the trial, meaning you will be capable of going home and returning to the courthouse each day. For the most part, we will work a regular business day, but on occasion it may be necessary to work a little bit longer based on the witness schedules. I will do my best to adhere to a regular schedule so it will not disrupt your lives. Please give some thoughts as to whether any of you may have a major problem, including a physical issue, that would prevent you from giving this case your full attention and performing your duties as a juror. Please be patient with us as we will be working as efficiently as possible. The bailiffs, the clerks, and court administration will be assisting here in the courtroom. Please follow the bailiff's or clerk's instructions. You are not to discuss this case while you are waiting or anywhere else until you have been excused. Also as well, there is reading material that has been provided by the court in the form of some magazines that are available to you if you would like to read. You also may look at your phones, but you are not to speak to each other or have any conversations about the case or anything else. For this instruction, does anyone have a question? Because I want to clear this up before we get underway. Again, you are not to speak to each other. You are not to discuss the case. You may look at your phones. You are not to look at any material that is related to this case. You also may read the reading material that has been provided by the court. Please do not listen to or read any media accounts on your phone or anywhere else until you have been excused. We will begin with the individual process at this point. If the parties please can relocate to the jury room, we will call each of you by your number, and from there we will go through the individual screening. If the bailiffs also can position themselves through the room as need be to make sure the orders are going to be enforced.
Hi, everyone, and welcome to Surviving the Survivor. This is the COE. In case you missed it, Joel is on his way to Tallahassee, Florida. So he will be coming to us from Tallahassee live tonight. In the meantime, we are showing you what we are allowed to show you today from jury selection. There are obviously a lot of limitations in the process. So earlier, if you missed it, you can rewind and you can see Judge Everett as he explains instructions to jurors. But right now, what you're looking at is not a camera feed. This is a photo from Tallahassee Democrats reporter Jeff Burlow, who has been a great reporter covering this case really since the beginning. He's also one of Joel's friends and is a friend of the show here at STS. So I do want to let everyone know that what you're looking at right now is a photo, and he's just showing us a little bit of the behind the scenes look at what's going on. I'm sorry, my dogs are distracting me. And again, we are not seeing the juror. We won't be showing any jurors on camera. That's obviously illegal. And whatever we can show you guys here throughout the day, we'll be showing you. If you see the seal up and you don't hear anything, that's because we're not allowed to hear anything. So we're just going to take it hour by hour with you guys, and we plan to keep this up the entire day. If we get any updates, we'll let you know. And then again, throughout the day, we are going to have some best guests hopping on when they can, but they have full-time jobs, so we'll just sort of play that by ear. Thank you so much, everyone, and please remember to hit like, subscribe if you're new, and we appreciate you. Thanks so much. Hey everyone, and welcome to Surviving the Survivor. Joel is on his way to Tallahassee. I do want to give you guys some updates for those of you that are just joining us. If you don't hear anything right now, that's because we don't have any audio. A lot of today is not going to be made public for us. So when we hear anything or when you see obviously the camera shift and you see Judge Everett, that's because we're allowed to see it. So we are going to keep this stream up all day. That way we don't miss out on any of those key moments, but there are going to be a lot of slow times, a lot of quiet times like right now where we're not seeing what's going on. I am going to pull up this photo. This is a still photo that Jeff Burlew from the Tallahassee Democrat took. This is what is going on right now that we're not able to see behind the scenes. They are interviewing various jurors and questioning them to try to find out who will or will not make the jury for Donna Adelson's trial. This is an image. Again, this is not a stream. This is an image that you're looking at right now. And this is another photo that Jeff also tweeted out. You can obviously see Donna Adelson there, a very different look than what she has been wearing the last couple of times that we've seen her there. She's now in civilian clothing, very similar demure haircut. Her demeanor seems obviously very calm yet very serious there. So these are just two photos that Jeff tweeted out. I also want to share some updates that Jeff has been tweeting. If you're not following him, again, he is a friend of the show. He's a friend of Joel's, and he is a longtime reporter for the Tallahassee Democrat. He's very well respected there locally in Tallahassee, and he's on Twitter, Jeff Burlew. Joel will be giving us updates from the courtroom starting tomorrow, but he is driving up from Miami to Tallahassee, which is a very, very long drive. So in the meantime, thank you to Jeff, who's been tweeting some updates. This is what he says. He says, Everett has yet to rule on a motion to suppress, which involves a jailhouse snitch who was close to Adelson and parts of a motion in limine. He also said that Everett said he will rule on outstanding defense motions before group jury selection begins later in the process. Donna Adelson was in courtroom 3G at the Leon County Courthouse. We saw her earlier today in the feed. So if you missed it, you can rewind this feed. And at the top, you do see Donna Adelson walking, and you also see Judge Everett giving jurors instructions about what's going to be happening today. Now, according to Jeff, who is there in the courtroom and is seeing what is happening, he says another juror told Everett that he was familiar with Donna Adelson's case and that he had watched a good part of Charlie Adelson's trial, which, as we all know, was live streamed in 2023. Judge Everett asked the man, "Do you have an opinion?" The man said, "I do. I think she probably did it." So Everett excused that juror. Then Jeff says that Zellman asked, "You already think she's guilty?" And a juror said, "Yes, it's my opinion as of now." He said that that opinion wouldn't sway him, though, and that he would consider the evidence in front of him. So Jeff is giving us some insider information there in terms of what's happening and what he's able to listen to as Judge Everett and both the defense and the state give us some, questions some individual juries there. I am going to pull this photo up here again. This is that image that Jeff tweeted out. This is what they're doing. And we do not have any audio of this. And we're going to share Jeff's Twitter feed with you guys. Julie or Copperhorse, if one of you guys can share that, we definitely support Jeff, and we'd love if all of you guys follow him on Twitter. He's very informative, and again, he is a friend of Joel's, and he's always been very helpful and very kind. So we definitely want to support him. We also have a poll there in the chat. We're going to continue to bring you guys some updates. I am going to put the feed back up for you guys so that you can see the feed and just be on standby. We do have the chat right now. And again, if you guys need anything, please flag us when you see anything change on the screen. That means that, again, we are going to be able to hear or see something. Until then, we are going to keep this up and just sit around and wait and hope to get more information. We do have a couple of best guests that are expected to hop on throughout the day. But as you guys know, all of our best guests also have full-time jobs. So we're just sort of on standby and waiting to see when someone can hop on. Thank you so much to everyone for being here. If you're new, we appreciate you. If you've been here from day one, we also appreciate you. Please remember to hit like, subscribe, and you can always join the STS membership. We appreciate that as well. And a big shout out to Space Coast, who is doing everything behind the scenes today and the rest of the trial every single day, all day long. And also to our STS mods who volunteer their time. And obviously to Joel and to our best guests and to Steve Cohen. Thank you so much to everyone. It really does take a village and we appreciate all of you guys. All right, I will be in chat if you need me. I'm the COE. That's the chief of everything. It started off as a joke, but that's what Joel calls me now. And I am also Joel's wife, for those that don't know me, excuse me. All right, get some coffee and let's just sit tight. Let's see what happens today. Thanks so much, everyone. Hey everyone, it's the COE here. For those of you who are asking whether or not Harvey is there, I'm unsure if he is in the courtroom. Again, he's not there. He's not there with Judge Everett and obviously the defense and the prosecutor and Donna, where they're questioning jurors. But I'm trying to figure out whether or not he's there. We do know that he was there yesterday in Tallahassee. So we assume he will probably be there for the entire trial. And in case some of you guys missed it, I do want to share these photos from yesterday. Here you can see Harvey on the left of the image there. You can see him sitting and he is having a moment with Donna Adelson. If you look closely at Donna, you can see she's reacting to him looking at her. So, I'm being told that Harvey is there. But this image was from yesterday at the last minute hearing for Donna Adelson's trial. And then there is this new photo, which many of you have already seen, but for those of you that haven't, this has been getting a lot of buzz all over social media. This was a photo taken yesterday by the Tallahassee Democrat photographer. And we're not sure if he was waving to Donna, if he was waving to the camera, but he was definitely waving and looked very cheerful considering he's there for his wife's murder trial for the murder of their ex-son-in-law. So this is an image that I'm sure Joel will address tonight on his live show. I believe Joel will be live at either 7 or 8 p.m. Eastern time tonight. He's going to give us a full recap with best guess on everything that happened today during jury selection, and also what can we expect tomorrow and the days leading up to opening statements for Donna Adelson. Again, Joel is on his way to Tallahassee with Steve Cohen. It's a long drive from Miami to Tallahassee, so it's going to be a while before they get there. But in the meantime, we are showing you the stream, and I'm going to pop off here because it looks like there might be some action. Hey everyone, and welcome to Surviving the Survivor. If you've been watching with us all morning, thank you. If you are just joining us and you don't hear any audio or see anything, that's because we're just standing by and waiting. But so many of you have questions about what's going on behind the scenes right now for jury selection. And quite frankly, I don't have any of those. So I decided to phone in a friend, and our friend is the one and only Josh Ritter from Courtroom Confidential. Here he is. Hey, Josh.
Good morning. How are you?
Thank you for coming on within 90 seconds of my text. I appreciate
No
you.
worries. No worries at all. That's what I do. I just sit here by my computer waiting for phone calls.
Thank you so much to you and Tiff. So we do have a lot of questions, and a lot of people keep asking, what is going on behind the scenes? What can't we see? Obviously, today is a big day. It's day one of jury selection, and we don't see any audio. We don't see any video, but we know that Donna and her defense team and Judge Everett and the prosecutors are behind the scenes right now, and they are questioning jurors. So give us a little bit of a scene setter of what's going on behind the scenes.
Sure. So I imagine with a case of this size and magnitude, they may have had the jurors fill out questionnaires. I'm not sure that if they already talked about that. Forgive me if they have, but sometimes that's what a judge will do. Sometimes they'll just do the entire voir dire process through questioning in open court. But they are they're trying to figure out who these people are. I mean, you're pulling in dozens and dozens of perfect strangers, maybe people who have zero experience with the court system, people who just responded to a jury summons, and their first goal they're trying to accomplish is, can these people serve for reasons like, do they have the time to do this? This is, this trial is going to take, say, 2 weeks. Do they have that much time that they can be away from their job and from their children and whatever other responsibilities they have in life? A lot of people will get time disqualified. Then you've got people who may have heard about the case, people who feel for whatever reason they cannot sit as an unbiased juror on this case. You start to knock out huge groups of people early on. And then it becomes much more about who are these people and are they the type of jurors that either side wants sitting on this case. I think a common misconception about jury selection is that we think of it as the attorneys picking the jury as if they're saying, I like juror number 4, therefore I want them to be on the jury. It's much more about picking the people you don't want on the jury, because you're trying to identify those folks, whether you're the defense or the prosecution, that are not going to be favorable to you for whatever reason. It doesn't necessarily mean that's an unfair person, but maybe they have some sort of bias. Maybe there's something about their background. Maybe they're, super pro law enforcement. And as a defense attorney, you feel like that's just not going to be helpful to me. Or maybe you feel as a prosecutor that there's someone who's just kind of prone toward conspiracy theory, and you don't feel that that's going to be helpful to your case. You're identifying the problem people for you. And what you're left with after you kick those people out, the opposite side is probably kicking out the people that you liked. They've identified the same people you like as the people they don't like. And what you're left with is a group of people that both sides had either no real issues with or very little about. I will tell you, almost every single time I've picked a jury, when I am done and they are sworn and they take an oath and you realize these are the jurors, double jeopardy has now attached and you are headed to trial, I will take a look over at the jurors and I'll think to myself, there's 12 people I don't really know much about at all. Now, in a case like this, they're going to get much more time and much more opportunity to learn about these folks, but it's really the ones who are left over after having voiced very strong opinions either way that are the ones that get kicked out. I hope that makes sense.
No, it does. And thank you. We're so grateful to have you here. And Josh, so right now they've gone through about 22 jurors. So far, we know that one is for sure being picked. So how slow or how fast is the process? And is that pretty typical? And then also someone has a question here for you. It's Mr. Brindle. They're asking, is it common practice for defendants, meaning Donna Adelson, to sit in on jury questioning?
First to that question, it's very common. They are not only entitled to be there, it's almost required that they be there because this is their jury. These are the people going to be deciding their fate. Many times defendants want a say in all of that. I've seen some defendants who are very involved in the process, huddling with their attorneys, writing notes themselves, talking about people who they like or don't like. And then other times you'll have defendants who just sit there and are kind of tuned out during the entire process. I think they said last time around, it took them about 3 to 4 days. I would say for a trial that's expected to take this long and a trial of this seriousness, that's probably typical. As important as a case as this is, it's not overly complicated in that you have multiple defendants all in the same trial. That is usually what causes cases to go into great amounts of delay, because you have to think that now you have, for every defendant, you have a set of attorneys, and every one of those attorneys is going to want their opportunity to speak to the jurors. And that process just, causes everything to increase in length. But I wouldn't be surprised if we have a jury by the end of this week. I think I would be surprised if we don't have a jury by the end of this week. I would, if you had me hedging bets right now, I would say we pick a jury this week and probably go into opening statements by the beginning of next week.
Yeah, and I think they said they're trying to see if they can even start on Friday. That's assuming, obviously, that it all gets done by Thursday. So we'll see. Julie Frew here has some updates. So Juror 25 is brought in. She said that she was an FSU student at the time of Dan Markel's murder and that she does read the newspaper and other local news. So, Josh, there have been a couple of people who have said, I do know the case. I've heard of it. What kind of positioning would someone like that be? What if they, can they still be impartial? Can they still go into this and be unbiased? Or do you think at this point they're just getting rid of anyone and everyone that has any inkling of, information or some kind of feeling about this case?
Such a great question. And it goes to the heart of kind of what is the ongoing tension between attorneys and judges when picking jurors. A juror like this, just because you have knowledge of the case, just because you've read about it, just because you're familiar with it, does not automatically eliminate you as a potential juror. The judge is going to turn to that juror and go, great. In all that you've learned, have you formed a bias about this? Do you have a conclusion that you've already arrived at in your head? In other words, have you prejudged this case, or can you keep an open mind? Every single person will answer the judge with, no, I can keep an open mind. It's the rare person who I think either wants to get off of the jury or is honest enough to say, no, I've already kind of made up my mind about this thing. When they answer the judge with that answer, now it's on the attorneys to either try to reveal some sort of bias that they might have that they're not being so forthcoming about, or just decide to use one of their peremptory challenges on them. The thing that attorneys are trying to avoid is using their peremptory challenges and getting somebody kicked for what we call for cause, meaning that the judge feels there's some reason to let that person go and the attorneys don't have to use their peremptory. The example that we just saw there is somebody I'm sure the defense doesn't want on their case. I don't think the defense wants anybody who's heard anything about this. If you're the prosecution, you're probably don't have that much of an issue with somebody who's heard about the case. So the defense is going to try to argue to the judge, this person has read about it. They were at the school at the time. Of course, they have some strong feelings about this. But if they're able to answer the judge with, nope, I can be fair in this trial, the judge says, move on or use your challenge.
And you were absolutely right. So she has moved on. The FSU student was excused. And Abby Crossing here has a question for you, Josh. And she says, for those that are through right now, and again, I believe we only have one person that is through, and it is a female in her 50s, I think. Do we know if this is just on to the next round, or do we know if that means they're actually being sat on the jury?
That's a great question too. And the answer is I'm not quite sure, because every judge does things differently. My guess is that what that just means is that they're on to the next round, that this is kind of their initial vetting process to make sure that, like I said, These are people who are time qualified. There's no reason that they cannot serve because they have other obligations. These are people that don't have immediate kind of knowledge of the case that would immediately disqualify them. And then once they get that larger pool of people, then they start the process of the attorneys beginning to question them, learn a little bit more about them. What do you do for a living? How many kids do you have? What are your thoughts on law enforcement? All those kind of good questions that attorneys want to hear. But every court does it different, like I said. So it could be that they're picking these people one by one. I've just never seen it play out that way. I'm used to us ending up with kind of this overall pool of jurors. And now you begin your voir dire process where the attorneys really begin to kind of question them personally. And then they begin to exercise their challenges from there.
And Josh, I'm asking a question about the physical layout that we're looking at right now for this photo. And excuse me, because I'm just a civilian. So if this is a silly question, as I'm looking here, I'm trying to figure out, I assume that the juror or the potential juror is off camera. This seems like a very intimidating setting.
Yeah.
Is this normal? Is this
no?
Okay.
If this is what they're, sorry to cut you off, but if this is what how they're doing the actual jury selection process, then this is very different. Usually it's done in open court in front of everyone. If someone has some sort of personal issue that they want to speak about privately, they will take them back into chambers, or this to me almost looks like it might be the jury deliberation room that they'll sometimes use for purposes like this, and they'll bring them back and individually question them. It looks like that might be the court reporter in the back there actually transcribing everything that's taking place. But to me, if they're doing this one by one, which is with each of these jurors, questioning them individually, that's going to take a long time. And I've never seen it play out exactly that way before.
And what's the big takeaway today? I mean, obviously it's jury selection. We're trying to see if anyone, makes it through. But as an attorney, as you're watching this play out today, as you're looking ahead, what are things that we should sort of be on the lookout for?
Honestly, this is one of the most important parts of the entire trial is the jury selection process. It's something that doesn't get talked about enough, and it's the importance of it, I don't think, can be overstated. Many times, how many times have we covered trials and it ends up with a hung jury because of one juror or two jurors? I don't think that has to do with the way that the evidence in that trial played out as much as it's not realizing you had a juror who got through that just had some very strong feelings they were never able to kind of put aside. So this is an incredibly important process, and a process that I think is rushed far too often. So I hope that Judge Everett is allowing the attorneys to have their opportunity to really vet these folks, to make sure, again, you're not trying to pick people who are going to win for you. You're trying to pick people who are just going to be open-minded and unbiased and give this case a fair shot and thoroughly listen to everything. If you're the prosecution, as in most prosecutions, I don't think there are any issues in this case that are so particular that you really want to dive into. It's not like a particularly political case or a case with a lot of kind of racial undertones or something like that. I think you are looking for common sense folks. When I was a prosecutor, I would always try to find the guy that kind of had his fingers crossed over his chest and sat there, a blue collar looking fella, a person who was just a common sense type of person, because that's the way you're going to play this out. It makes sense that Donna Adelson would be in on all of this, that she would understand what was going on, that the conversations she was having, that, where she was trying to disguise the subject matter of what she was talking about, that we all know what she was talking about. If you're the defense, you're probably looking for just the opposite. You're looking for people who are a little more skeptical of law enforcement, people who are a little more inclined towards perhaps believing conspiracies, because you're going to ask them to believe something that is, a little far-fetched, that this woman, despite all of the evidence that we know about, really had no idea of what was going on. And that is a particular type of juror. Or you're looking for people who just run against the grain, people who are happy to be a holdout. Those are also the types of jurors I think the defense is looking for.
And Josh, right now we're seeing a close-up photo there of Donna Adelson. She is the woman that is going on trial for the murder of her ex-son-in-law, Dan Markel. Her look, obviously different than what we have seen the last couple of hearings. She's now in civilian clothing. Talk to me just a little bit about what she looks like. I know that you had predicted that they would very much try to create a certain image now that jurors were going to be assessing who she is and whether or not she is guilty of what she faces.
Yeah. I said be on the watch for sweaters and Kleenex. And that's, I think, exactly what we're getting, is that she's going to come in looking like a grandmother, like a sweet old lady who would never harm anyone, certainly would not tangle herself up with gang members and Latin kings and paid assassins, and would have nothing to do with harming anyone, let alone taking the life of the father of her own grandchildren. That is her testimony begins, pardon me, from the second the jurors walk into the courtroom and they take a look at her. Jurors do this. The star of that courtroom at all times is the defendant, whether the defendant's on the stand or not. They look towards the defendant to see how are they reacting to testimony that was just said in court. How are they reacting to what the prosecutor just said in opening statements? They want to see this person who's the star of this entire show. How are they responding to everything as it plays out? And that includes how they dress. I mean, I've had long conversations with clients about, the proper way to present yourself in court, the proper way to behave in court, because you're being microanalyzed, certainly by the jurors. And so I'm not surprised. This is kind of, defense attorney 101 is make sure the client does not look like the type of person who could commit the crime they're accused of.
Absolutely. All right, Josh. Well, thank you so much. I appreciate you being here. I know that you have some more interviews at the top of the hour and some work to get back to. But obviously, if you want to say anything else, please feel free to. If not, I just wanted to thank you. If you guys are not familiar with Josh Ritter, that means you guys have not watched enough STS. Josh is a regular best guest here. He also hosts his own show, Courtroom Confidential. You can find it on YouTube, on all of his audio platforms as well. He also has a website, courtroomconfidential.com. He's a great guy. I adore his wife and their 3 little kiddos. So thank you so much, Josh. Any other final comments?
Oh, thank you so much for having me. Yeah, I think this is really going to, I'm curious to hear who we end up with, because really, like I said, it can't be overstated how important this process is. This could honestly make or break the rest of the 2 weeks that are about to follow of evidence if they don't get this right here.
Yep. No, this will be a big day and a big week. All right. We will have you back, I'm sure. Probably
so
sooner
much.
rather than later, Josh.
Take care, everybody.
All right. Take care. Bye. All right. Thanks, everyone. So as you just heard, we are just sort of standing by and waiting. We're going to continue to bring you guys updates as we have best guests available. We'll have them hop on and give us their take, just like how Josh Ritter did. Again, he is from Courtroom Confidential. He hosts his own show, and he's also obviously a friend of the show, a friend of Joel's and mine. All right. I'm going to put this feed back up here. That way we can continue to be on standby. And again, we are just going to be here in chat. We do have both of our OG mods. We have Copper Horse and Julie Frew. They're bringing us updates. I want to thank both of them for being here. They do volunteer their time. So if you'd like to donate a coffee to them, there is a link here in the chat that you can do that. And again, thank you to all of you guys for being here with us. We're going to keep the stream up all day, regardless of whether or not there's audio. And yeah, we're just going to be standing by. So thanks so much. If you need anything, I'm in the chat. You can flag me. We do have a live show tonight at 7 p.m. Eastern time with Joel. Joel is driving up from Miami to Tallahassee. So hopefully he gets there by then. All right. Thanks so much. And we're on standby.
concerning not discussing this case with anyone else, not watching any news reports. That is going to apply to you again until you are excused in this matter. Does anyone have any questions concerning this before you leave my presence? Please raise your hands. There are no bad questions, a teacher might say. Yes, ma'am.
Thursday, we know how long.
For that, once we go through the group jury selection process, I cannot tell you how long it will run, but we're anticipating on that day finishing the jury selection process, the jurors who are selected being sworn, and we go through the opening statements. After that, you will be discharged for the evening. As much as possible, we're going to try to stick to an 8:30, 5 o'clock day if you are selected as a juror. We may have to make exceptions on certain days, but that is the goal. Any other questions before you are dismissed? Yes, sir.
If we were currently here, we expect to return Thursday.
That is correct. Thursday at 11 a.m. Any other questions?
Should 11,
Yes, ma'am.
should 11 a.m.?
11 a.m. on Thursday, report downstairs where you started off today. Okay. All right. I will see you Thursday. Oh, one more?
No, yeah.
Go ahead.
So if we're not the actual jurors that you guys are choosing, we just are taking one. It won't relate to that until after that. So if I need to address it, then now I can address it now. It's work related, but I know with y'all with
Say-
court
say-
that'd be
Save it for Thursday.
Okay.
Believe me, we'll get it out.
yes, sir. No, sir. No problem.
Any other questions?
Now,
Yes, sir.
Just to reiterate for my clarity, so this.
State and the defense on Thursday.
Okay.
You are not a juror right now. You are still a prospective juror. You've just gone through the first round of screening.
Okay.
Don't read anything. Don't watch anything. Anything else? Have a good lunch break. See you Thursday.
Yes. Give me your numbers.
Hi, everyone. It's the COE here. So in case you just missed that, Judge Everett dismissed a handful or two of people who have made it through to the next round. They are not jurors yet, but they could potentially be jurors. They got dismissed and they're allowed to come back Thursday at 11 a.m. There is now a lunch break for jury selection, and then the judge and attorneys are going to continue to question other potential jurors. So right now we are on a lunch break. And then the people that you heard leaving, those are potential jurors that made it through, and they're returning on Thursday at 11 a.m., where they'll then have more questioning and they'll hopefully find a jury. All right, so we're on a lunch break right now, and they're going to come back in about 45 minutes or so. We're here in chat. You can continue to talk about justice for Dan Markel and the upcoming Donna Adelson trial for the murder of her ex-son-in-law, Dan Markel. If not, we also have a 7 p.m. Eastern Time live show tonight with the host of Surviving the Survivor, that's Joel Waldman, and he'll be accompanied by a panel of best guests to discuss everything happening today and this week. Thank you so much, everyone.
We're just waiting on the jurors to return at 1:45 at this point. Are there any matters that we need to address before we continue?
Guys, can we approach?
Yes. Okay, go ahead.
This way. We're gonna go all the way down to 51. Right here. Good afternoon. I'm here. Right this way, sir. Good afternoon. Still in right here. 55, 56. Good afternoon. Here. You'll start my next row all the way down there. Good afternoon. All the way down. Right here.
I know it. Take my bag. Yeah. Do your thing.
Everyone can be seated at this time. Good afternoon, ladies and gentlemen. Take two. Good afternoon, ladies and gentlemen. Thank you. I'm Stephen Everett, one of your judges in the Felony Criminal Division here in Leon County. You have been summoned here this afternoon as prospective jurors in the case of the state of Florida versus Donna Adelson. This is case number 2023 CF 3226. This is a criminal case. The state has charged Mrs. Adelson with the crimes of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. You will notice at times during this jury selection process today that I will be reading to you. It is not that I do not wish to have a free-flowing conversation, but rather any explanations on the law that you will receive throughout this process must be uniform and must be specific according to the Florida Supreme Court. Is the state ready to select a jury this afternoon?
Yes, Your Honor.
Is the defense ready to proceed as well?
Yes, Your Honor.
And for the record, I'm noting that the defendant is present in the courtroom with her counsel. I believe earlier this afternoon, Judge Riggins qualified everyone. However, I am going to confirm with the qualification if there is anyone that needs to be excused on a statutory basis. That will happen before we move on through our process this afternoon. When I ask the following questions, please raise your hands if you are responding yes to the questions. Is everyone here that is a prospective juror at least 18 years of age or older? Please raise your hands if you're over 18. For the record, I will find that the prospective jurors have answered in the affirmative. Is everyone here a citizen of the United States of America? Once again, for the record, the prospective jurors have answered in the affirmative. Is everyone here that is a prospective juror a resident of Leon County? Again, the prospective jurors have answered in the affirmative. Do each of the prospective jurors possess a driver's license or identification card that's been issued by the Department of Highway Safety and Motor Vehicle, or have you executed an affidavit as to your eligibility to serve as a juror? Once again, the prospective jurors have answered in the affirmative. Once again, please raise your hand if your answer is yes to any of the questions that now follow. Has anyone been convicted in a state or federal court of a felony crime or a crime involving dishonesty, and your rights, your civil rights, have not been restored to you? None of the prospective jurors have raised their hands in the affirmative. At this time, is anyone under prosecution for any crime, either in a state or a federal court? No hands have been raised for the record. The next grouping of items that I'm going to go over are people that may be excused by statute for falling into a specific grouping or class. If you can go ahead and silence your cell phones at this time. After I ask the question, if you are responding to this particular basis to be excused, please raise your hand and I will address you separately in just a few moments. Is anyone a full-time sworn federal, state, or local law enforcement officer or investigative personnel? Please raise your hand if this applies to you. No hands have been raised in response to the question. Is anyone an expecting mother or a parent responsible for the full-time care of a child that is under 6 years of age, and there is no one else to take care of the child? No hands have been raised in response to the question. Is anyone present 70 years of age or older? No response has been given to the question.
Has anyone performed state jury service within the last year? The last year meaning August 19th, 2024 to today. No hands have been raised in response. Is anyone responsible for the full-time care of a person with a physical or mental incapacity who is incapable of caring for themselves, and you being here today will create a hardship for them? No hands have been raised in response. Is anyone a full-time student between the ages of 18 and 21 who is attending high school, any state university, post-secondary educational institution, Florida college system institution, or career center? Please raise your hand. All right. I will address you in just a moment. Are there anyone else in the back? One hand was raised in response. I believe lastly, has anyone given birth within the 6 months before your reporting date on the summons, which would be today? Please raise your hands. No response has been given. Right, the one hand that was raised, please approach the bench. The attorneys may come up as well. The first thing that we're going to do this afternoon is discuss what some of you may know about this case. This case has received some publicity in the past, and there has also been a related case that was tried nearly 2 years ago. This process is going to be handled individually because you all don't need to know what the others may know about this case. However, before we start the questioning, I'm going to give you some very important instructions. Many of you have cell phones, computers, and other electronic devices that you have brought with you. Even though you have not yet been selected as a juror in this trial, there are some rules that you must follow about using your cell phones, electronic devices, and computers from this point moving forward. You must not use your phones or devices to search the internet or to find out any information that is related to this case. Between now and when you have been discharged from jury duty in this matter, you must not provide or receive any information about your jury service to anyone, including your friends, coworkers, and family members. You may tell those who need to know where you are that you have been called for jury duty. If you are picked for this jury, you may tell people that you have been selected for the jury and how long the case may take. However, you must not give anyone any information about the case itself or the people that are involved in this case. You must also warn people not to try to say anything to you or to write to you about your jury service or the case. This includes face-to-face communications, phone or computer communications as well. In this age of electronic communication, I want to stress that you must not use electronic devices or computers to talk about this case. This includes tweeting, texting, blogging, emailing, posting information on a website or chat room, or through any other means at all. Do not send or accept any messages, including email and text messages about your jury service. You must not disclose your thoughts about this case or your jury service, or ask for any advice on how to decide the case. Further, you must not read nor listen to any news accounts about this case until you have been excused by the court. Avoid the newspaper and television broadcasts, particularly the local news stations. Also, avoid social media or any internet news sites. I am now going to provide to you a statement of the case that has been agreed upon by the parties. On July 18, 2014, FSU College of Law professor Dan Markel was shot while seated in his car. This happened in the driveway of Markel's home on Trescott Drive in the Benton Hills neighborhood. The killers traveled to Tallahassee from Miami to commit the murder in a rented silver green color Prius. The defendant and alleged conspirator in this murder was the former mother-in-law of Dan Markel and has entered a plea of not guilty. I will also now read to you the material part of the indictment that has been filed against the defendant. Count 1. It is alleged that on or about July 18 of 2014, Donna S. Adelson in the county Leon and state of Florida did unlawfully kill a human being, Daniel Markel, by shooting with a firearm, and the killing was perpetrated from or with a premeditated design or intent to effect the death of Daniel Markel, contrary to the Florida statutes. Count 2. It is alleged that beginning in 2013 until October 1st, 2016, Donna S. Adelson in the county of Leon and state of Florida did agree, conspire, combine, or confederate with Charles Adelson and or Catherine McBanawa and or other persons to commit first-degree murder contrary to the Florida statutes. Count 3. It is alleged that beginning in 2013 until October 1st, 2016, Donna S. Adelson in the county of Leon and state of Florida did solicit another to commit first-degree murder, and in the course of such solicitation, commanded, encouraged, hired, or requested the person, Charles Adelson and or Catherine McBanawa, and or other persons to engage in specific conduct which would constitute first-degree murder, which resulted in the death of Daniel Markel, contrary to the Florida statutes. The statement of the case and the indictment I have just read to you are not evidence and are not to be considered as evidence or any proof of guilt. You must not be influenced by the fact that an indictment has been filed in this case. It is merely a formal method by which the state makes an accusation against the defendant. We are now going to talk to each of you individually and privately about this case. Some of you may be excused. The rest of you will remain to participate in the next phase of the jury selection process. Individual voir dire is time-consuming, but will go a lot smoother if you are prepared to tell us the information that we need to know. These are the basic questions that you will be asked, or some variation thereof. What about this case? What sources have you obtained this knowledge from? Based on what you know, do you have an opinion about Mrs. Adelson's guilt or innocence? Can you set aside your present knowledge, disregard it, and render a verdict solely on the evidence presented in the courtroom? Can you be a fair and impartial juror? Do you have any reason that you cannot serve on the jury for potentially up to 3 weeks? It will save us all a lot of time if you think about these questions and be prepared to give us a prompt answer when you are called back. The last question that we will discuss with each of you individually deals with hardship. We expect the jury selection process to take until Thursday of this week. After that process is complete, we expect the trial to start on Friday and last for 2 weeks. All in total, we expect the proceedings from today will take up to 3 weeks. We understand that it is a burden for anyone to serve for that length of time. However, we cannot make our system of justice work unless we have good people that are willing to do their civic duty and serve as jurors. Similar to military service, we do have to call on our citizens to make sacrifices, and jury duty is one of those times. You will probably never be called on again to serve in a trial of this length and nature. However, I understand for some of you, service in this matter may not be possible under the circumstances. To give you a little more information about what this will involve, you will not be sequestered during this trial. What that means is you will be able to go home as you normally would and return the next day. For the most part, we will work a regular business day, but on occasion, it may become necessary for us to work a little bit longer based on the witness schedule. I will do my best to adhere to a regular schedule each day. So please give some thought to whether any of you may have a major problem, including a physical issue that would prevent you from giving this case your full attention for the time period in which we are discussing. Please be patient with us. We will be working as efficiently as we possibly can. The bailiffs, clerks, and court administration will be assisting in the courtroom. Please follow the bailiffs or clerks' instructions. Do not discuss this case while you're waiting here or anywhere else until you have actually been excused. Do not read or listen to any media accounts on your phone or anywhere else until you have been excused. Also, you are not to speak to each other while you are waiting to be examined by the court and the attorneys. You may read your phones. There are some magazines here available, provided as reading material, but ultimately you are not to speak to your fellow prospective jurors. Again, you are not to seek out any information about this case, but you may silently either read your phones, read the reading material that has been provided, or even if you want to, get some shut-eye, then don't start snoring, but you're not to speak to each other. Are there any questions about this before we get started? Very well, if the parties can come to the jury room at this time, we will get set up and then we will start summoning back each of the jurors.
Hey everyone, it's the COE here. Welcome to Surviving the Survivor. If you've been with us all day, thank you for hanging out for 6 hours now. If you are just joining us for the first time, yes, this is live. And yes, this is now the second round of potential jurors that Judge Everett has called in to question. So I just want to give you guys a quick explainer about what is going on right now, since some of you are just joining us. They are taking individuals back one by one, and they are asking them questions. Judge Everett is doing the questioning and the striking today. They started with about 300 people, and they're going 50 people at a time. So I believe we're now up to about 30.
Yeah, we're gonna have to be super clear on that.
Okay, this camera here is in the courtroom. I didn't know if they were coming in to say anything, but as you can see, that was just some background noise. But yeah, they're about. I think they're. We have Julie, if you can confirm with me how many people we have staying. But what Judge Everett said is they're going to continue to go through with potential jurors today. They're questioning them. And then whoever got the green light to stay will then come back on Thursday at 11 a.m. And at that point, everyone that moved on to the next level will be questioned all over again. And I believe at that point, it would be by the attorneys. Again, tonight at 7 p.m. Eastern Time, we are going to have a live show with Joel Waldman. He is the host of the show, and he's also going to have some best guests on to bring us some analysis and also give us further explanation about what is going on. And again, this is a process. So Mandy Strong is saying that no jurors have been selected. Of course, no jurors have been selected. These are all just potential jurors. And at this point, they're either sending people home or they're asking these potential jurors to stick around and come back Thursday at 11 a.m. for the next round. The judge and attorneys did say that they're hoping if things go well on Thursday, they'll be able to narrow it down and hopefully find a jury in hopes that they can start opening statements on Friday. If not, then it would be pushed to Monday. Some people are saying this has been a slow process. Others are saying it's been fairly fast. But again, as attorneys have been telling us, jury selection in the process is very different state to state and even county to county. In other cases, we've been able to see more and hear more. That's not the case today. So whenever we're not able to see anything, we let you guys know. We are giving you guys any updates. And if we hear anything, we are putting some stuff here in the anything that is big news, we put up here on the screen for you. But please remember to hit like, subscribe. And again, we are live today at 7 p.m. Eastern Time. I'm just posting the show now. And yeah, we thank you all for being here. Thanks so much.
Just return to your seat. Yes.
Hi, everyone. It's the COE here. For those of you guys that are joining us, while there is a mic open in the courtroom, the potential jurors and the judge and Donna Adelson, the defendant, and the attorneys on both sides, on the defense and on the state side, have left and are now in a different room interviewing and questioning the potential jurors. This was a photo that was shared earlier by Jeff Burlew from the Tallahassee Democrat. I'm going to pull it up here for you. And this is, let me just take that overlay off. Excuse me. Here we go. This is the room where they're doing the questioning right now. And this photo was shared earlier as well as this one, but there are some new photos that I want to show you guys. And again, we're not able to hear anything and we're not able to see anything. No videos and no cameras are allowed in terms of video cameras, but there is a still photographer that is allowed to go inside. So I want to share some of the images. I'm going to be pulling them up. Just give me 1 minute. All right, this is from today. This is Donna Adelson next to her defense attorney. And as you can see, she has her own notebook and her own pen, and she is sitting in that room. So while she is not a part of the questioning, we're told it's very normal and it's actually protocol and part of the legal system that she be there. But she is also taking notes and is very focused on what is being said and the details of these potential jurors. And as you notice, Donna Adelson is in regular clothes today. She was not wearing the purple or orange jumpsuit that we've seen her wear before. So again, I'm just sharing these photos here as they're just popping up right now. These are from the last 2 hours or so. Now, we are going to keep the feed up for the rest of the day until the potential jurors are released and until court ends for the day. But I do want to remind everyone that this stream does not have audio, and video right now is not able to be broadcast from the room that they're in. There is no audio and no video for the questioning. They have taken potential jurors inside of a room to question them individually. Whomever gets the green light to stay for the next round will be returning Thursday morning at 11 a.m. So again, this is the second round today. They started with 300. I think they let go of about 24, 25 people so far. We'll get the full update later today. And then this is the second round. They're trying to find more people that they can give the green light to stay. They're hoping to do that as well tomorrow. And then by Thursday, they're hoping to choose a jury so that they can begin opening statements on Friday. We're live at 7 p.m. Eastern Time tonight with Joel Waldman, the host of the show, as well as best guests. We're going to keep this stream up, but please remember to hit like, subscribe if you're new. If you're not new, thanks for sticking around. We appreciate you guys. You guys can also become STS members here on YouTube and also on other platforms as well. And we appreciate you guys. All right, thanks.
You're excused. Are you ready for 54?
And if you missed that, it sounds like they just excused juror 53 and now they're on to juror number 54.
return Thursday.
Okay.
55.
All right, it sounds like 54 is staying because she said to come back on Thursday. They're now on to juror number 55.
Put your gavel there, return Thursday. 56. Return Thursday. 57. Ready for 57? file. See you Thursday. 58. Turn Thursday at 11:59. Thursday. 60. We have had all of them. See you Thursday. 61. Coming back Thursday. She's going back to her seat. $61, you are released. 62, come in. Nope, you're going in. Yeah, you need that release.
Look at that.
Yes, sir. Returning Thursday, 63.
Go ahead and.
Forward, all right. Just hold it, y'all. Roll it up. All right. Let's go first, 64. That way. 6, 7, 8. Yeah, that would make sense for us to sit on the. Yeah. All the way down. So I guess you're right there. No, just go all the way down to the end. Yeah, backwards. Just front row. Yeah, front. There you go all the way down to the end.
Hi, everyone. I just wanted to check in and let you know that we have a best guest that will be joining us. We have a law professor, Jo Petuto. Hi, Joe.
Hi. Hi,
Hello.
everyone. I assume we're still muted while they're doing the private part of the jury voir dire right now.
Yes, we still are, and people are sort of wanting to understand more about the process, whether or not this is going quickly, slowly. Sort of walk us through what we can expect right now.
Okay. I can't really answer whether it's going quickly or slowly, one, because I just joined, and two, because it's not clear what's going on. But it is a typical process. What typically happens with jury selection is there's some general questions that a judge will ask all of the jurors. Some of them will be excluded at that point, sometimes because they're entitled to under statutory criteria. For example, many states say for citizens over the age of 70 or 75, they can elect not to serve on a jury. So those people will be excluded. They're also doing, according to what Judge Everett said at the hearing last week, they were also going to do some getting to the final voir dire pre-questions on pretrial publicity. And so that may be going on right now. And then there are questions that are either private to an individual juror, private information that the juror does not want to share with other jurors in the room, or questions that the judge does not want any juror to answer with other jurors in the room. For the former, for example, you might have a DWI conviction. For the latter, for example, it would be questions such as, have you seen anything about this trial? Do you know anything about this trial? Do you have a preconceived notion as to guilt or innocence? The judge would not want those answers to be heard by the rest of the jurors at this stage because it might prejudice the other jurors. So for that part, the judge, the prosecutors, the defense lawyers will be doing this privately, juror by juror. So not only do we not see this going on or hear it as viewers, but the other jurors also are not privy to it. So I'm assuming that's what's going on right now. This will take, until they get through a large number. Some states do it 50 by 50. Some states do it, they do the entire panel. I assume that what's going on here is they'll do it in groups and then see where they are. After that's done, the lawyers are also entitled to probe general questions, the background, do you have relatives in law enforcement? Do you understand what proof beyond a reasonable doubt means? Can you withhold judgment as evidence comes in until the trial, until the end of the evidence? Sometimes they ask those questions in cleverer ways, but you can generally tell by the questions that are being asked what kind of information they're seeking to elicit. And you also may be able to tell the general profile of jurors that the defense is looking for and the general profile that the state is looking for. That's the part that generally is done before the number of jurors that are waiting to have that question taken, the questions taken, and also us. And for those of you who may have watched Charlie's trial 2 years ago, there was a part of it that was public, and that's the part that would be public once they're down to a point at which the lawyers themselves are going to be able to ask questions. But even there, the judge will try to be very careful to not have a juror say something that might potentially prejudice the other jurors. Now, I see a question from Mary Binney about how many jurors can the state or defense can recommend. It's not really a recommendation, it's a striking. In theory, everybody who makes it through the preliminary rounds and is now being asked by the lawyers are already potentially jurors. And now it's up to the lawyers to say, for the particular panel, of the particular 12 or 15 counting the alternates that are going to sit, we want to look at the group that's sitting here and make some more refined, some more nuanced decisions. So they will be striking from the group that have been tentatively on the general question pre-cleared. And at that point, there are what is called for cause strikes or challenges and what are called peremptory challenges. For cause is somebody says, gee, my son is a police officer, my daughter is a prosecutor. That would tend to be a for-cause challenge. There's so much potential for an inclination to see the state's case more favorably that a judge would be likely to say that's for cause. For cause doesn't count against either the defense or the prosecutor's challenges. It is simply, now we've looked at the juror more closely and we think there's yet another reason to strike that is independent of what the defense or the prosecutor might do. Peremptory challenges is where, let's say I'm the defense lawyer, I can strike for any reason and I don't have to give a reason. Same thing with the state, can strike for any reason, doesn't have to give a reason. The only thing that the defense cannot do and that the prosecutor cannot do is to strike because of the race of a juror, the gender of a juror, any protected class in which the potential juror is. Can't strike for those reasons. That's unconstitutional. But otherwise, I can say, gee, that juror didn't look me in the eye. I don't have to say it out loud, but I can decide to strike because I say to myself, that juror didn't look me in the eye. Or that juror, I had a friend who was a prosecutor, for example, who struck somebody from the jury who worked for a circus because he didn't know enough about the inclinations of people who work for a circus. He thought he had some idea of the predilections of a social worker or a librarian or a teacher or a contractor or, you name it. But he had no familiarity at all with workers who would work with a circus that travels from place to place, and he didn't know what to expect, and it was too much of a risk, so he just struck that juror. Now, there are only so many peremptory strikes that each side has, so the prosecutor and the defense both have to be careful, because if you strike people that you're not certain about too early, you may not have enough left, and there may be somebody now whose name is called or whose number is called, and you really don't want that person on the jury, but you don't have a strike to use. So it's something of a tactical game, when you strike and how you strike. As to the number, I'm not certain what Florida does. It varies from state to state, but typically the number is about 10 or 12 peremptories for each side. Now, if there are other questions up there, please, the Batson rule is what I was talking about, which is you cannot strike members of a jury because they belong to a protected class. And if you do, let's say I'm the prosecutor and I strike 6 women from the jury, and I never strike a man. That might be a sort of a facial case for the defense to say, you're trying to keep women off the jury and that's unconstitutional. At that point, the judge may ask me to explain the basis on which I made those strikes and to demonstrate that it was not gender related. So I don't know if there are other questions up here. Let's say. Dave Finnegan, will we get to watch any part of jury selection? If it runs the way it did in Charlie's trial, yes, the last portion when the lawyers are conducting the voir dire will be televised, but I have no idea whether the judge is going to do it in this case or not. If they have 34 jurors for round 2, then it sounds like they will be able to seat a jury. I think that's true, but I've all along thought they'll be able to seat a jury. Most people, well, maybe certainly many people in a town, in a city, in a county, do not follow even well-publicized criminal trials. And so they will not have read, they will not have heard anything about a case. In this case particularly, that may well be true for a couple of reasons. One, Tallahassee is a college town, so that there's more mobility among the population moving in and moving out. Young people going to the university, faculty members at the university, and there are also government workers that may move in and out. So the population is not as stable as it might be in another city, and therefore there will be people who have moved in who obviously don't know anything about the case because they weren't there at the time of the crime. So that's one reason why the jurors would not know, or potential jurors would not know anything about the case. The other part of it is the striking of jurors and trying to get an impartial jury does not mean that I cannot have heard about the case. What it means is I have to persuade the judge that I am not biased by anything I heard about the case. So you will hear the judge ask, well, you now said that you read something in the paper a couple of years ago. Does that mean you cannot be impartial? You cannot wait until the state and the defense put their evidence in? And I will say, no, I can be impartial. I don't know very much. All I remember is there was something in the paper that said a trial was going on. And that typically will be enough. I will be an impartial juror and can be seated for the trial. Will it be a 6-panel or 12-panel jury? It will be a 12-panel jury. This is a first-degree murder case. So there'll be 12 jurors sitting. Do you think they will ask potential jurors about their relationship with their in-laws? That would be a permissible question, I believe, for the state or the defense to ask, because it runs to, you know, if I'm a juror and I say, gee, I despise my son-in-law, he treats my daughter badly, that would certainly be relevant to a trial in which a mother-in-law is being prosecuted for the murder of her son-in-law and was angry with the son-in-law because she thought that her daughter wasn't being treated well, among other things. So those are the kinds of questions that could be asked. Generally, lawyers try to be use a little more finesse than asking it quite that way. They try to get it on a slant, or they may say something like, you know, this case involves allegations that a mother-in-law, you know, paid to have her son-in-law killed. We don't believe it's true, but that's some of the evidence coming in. You know, how do you feel about that? Or is there a reason in your background or your experience that you would be inclined to credit that kind of, you know, that information about a mother-in-law? And, but in any event, that general line of questioning, at least to explore a little, I think is certainly going to be permissible here. Are students prevented from being a juror? No, I don't think there's any bar to a student. They have to be of the minimum age level to be seated. Students, I don't know whether, and maybe the CEO and E knows, I don't know whether Florida State has begun classes for the fall. But if it has, or if this trial is going to go a couple of weeks and classes may have started, a student may say, this is going to be a hardship for me. Classes are starting, and the first week or two of classes is really important. And this will be just really difficult. In that case, the judge may explore a little with the student just how difficult it will be, what maybe, you know, how the student's doing in school. And what is likely going to happen is the judge will ask if the defense or the prosecutor have any objection to the judge releasing that student from having to serve. Typically, both will say it's okay, that student will be released. But there's no rule in law that you can't serve on a jury because you're a student, an enrolled student at school. If you were on the defense team, would you want male or female jurors, young or Donna's age? I can answer the latter question pretty easily. From my perspective, I would like jurors who are Donna's age, because I think, assuming that the defense is what we have all projected it will be, that is, she's going to say, I knew something was going on, but I'm just this little old lady, and I love my son, and I trust my son, and when he tells me this is what is going on and what he needs, I don't ask questions. I rely on him. He's capable. I trust his judgment, and therefore I don't have to exercise my own independent judgment. I think that kind of defense will play least well on Donna's contemporaries, particularly contemporaries who are sitting on this jury, who are going to say, I'm that age, I wouldn't act that way. I'm not this doddering old fool that will believe any silly story my son tells me. I think young jurors are more likely to believe that, in general, not, any particular juror, there might be a different issue, because I think young jurors might think if you're over 50, it'll be a miracle if you can cross the street on your own without having somebody hold your hand and get you across the street. So it seems to me they would be more susceptible to a claim from Donna, look at me, I'm just too old and feeble-minded to be able to act it, independently and with my own independent judgment. Now, the first part of that question, male, female, I'm less sure about that. My inclination is I would prefer women jurors, but remember, this is not binary. It's not, I'm going to do it because this is an older juror. I'm going to do it because this is a female juror. Jurors are going to come with a whole bunch of qualities. Some may lean towards what I think would make a good defense juror. Some may lean the other way. So the woman juror who is older might be someone who has the kind of job that I think would be sympathetic to the defense case. Traditionally, if you've been to, some of you may have been to some lawyer conferences on picking jurors. Traditionally, the rule would be the prosecution doesn't want a social worker on the juror because the social worker in general, in stereotype, is going to be more caring, more responsive to nuances, more looking at how can I help this person as compared to, am I looking at the evidence, only the evidence. In the first trial, when Katie McBanawa, there was a hung jury. There was a juror on that panel who was young and female, and I believe was pregnant at the time or may have just given birth. And notwithstanding the evidence, that case, she was quoted afterwards, and some jurors, I believe, reported afterwards that she took the position that Sigfredo Garcia, the children's father, was going to go to prison for life, and she could not picture also putting the mother in prison for life and leaving the children without a parent. Not a reason that should have led to a vote of acquittal from her, but she's in the jury room and there's nothing you can do about it. Would that have been predicted? It may well be that the prosecutor looking at a juror who has just given birth or is pregnant might have said, maybe this juror is just going to be a little too sympathetic. So it's not just one or two things, it's a whole bunch of things, and you've got to weigh them and balance and then make a guess about it. All right. Is the depth of questioning of potential jurors relevant to the severity of the case? I was on a jury in my early 20s in a civil case, and I was barely asked anything. There's no roof. You can't open a book on jury selection anywhere, and it says, gee, lawyers are going to be permitted to be more probing in a criminal case or more probing in a serious felony case. But, kind of a rule of thumb, the likelihood is that's probably true. The more serious the consequence to the defendant, the more careful the judge is going to be that the jury that's impaneled is as impartial as can be done. and probably the more latitude he's going to give the lawyers on the defense side, and probably the prosecution too, to explore more fully what the each juror before before making a decision about whether to strike a juror or not. Okay. Here's Auntie M. Will the jurors need to be unanimous on guilty or not guilty? Yes. For at least murder one, can't have a non-unanimous jury. Now, it's constitutional to have a non-unanimous jury. You can go down, I believe, as far as 9-3 on a jury where there are 12 members. But in Florida, you need a unanimous jury, at least for murder one. And that's the rule. I don't want to say in every state because I have not looked at every state, but certainly that's the rule in the great majority of states. You're going to need a unanimous jury. So one juror can hang the verdict. Now, saying that, the research on juries, and there's a lot of research on juries, is that the one holdout or the two holdouts in general, sooner or later, will accede to the arguments of the majority, and you'll get a unanimous verdict. Now, of course, the case I gave you with regard to Katie McManus' first trial is an example where that didn't work, and that holdout was adamant that she was a holdout. Sometimes the jury comes back, with a question, and unfortunately, none of the feeds in any state show you the jury. But for those people who are sitting in the courtroom, what you will see often when jurors consider themselves deadlocked or they're having trouble agreeing and they come back with a question or they come back seeking more information, you can tell by the way they're sitting how they're viewing the case. They'll lean into the people they agree with, and if there's there are one or two that are on the other side, they'll be sitting a little isolated. So as a rule of thumb, if you're in the courtroom, you can often have a pretty good guess as to who are the parties in the dispute on each side of the dispute. CJ asks, doesn't the I trusted my son defense affirm his guilt? Well, it might well affirm his guilt. She actually doesn't have to say, I believed him, and so he's guilty, but you can't blame me. I'm just a poor mother who loves her children, because she can say, I believed him, and I think he was telling the truth, and maybe get away with that. But I think, CJ, you're right. The likelihood is the jury is going to decide that believing him separates herself from his conviction or his guilt, but it also underscores that he was guilty. Okay, do I agree? It is more about the personalities and their own experiences rather than gender. Could be. I really can't. It's hard to answer because, as I say, there may be so many factors that go into a lawyer picking a jury and looking at particular jurors. And so you might say, hey, in general, the other things are going to matter more. But in a particular case, a lawyer may have made a determination that, gender is going to be really important here. Because in general, women are going to be either more sympathetic or not as sympathetic. And even though I'm getting good vibes from this juror, I really think the general information is what I'm going to rely on rather than vibes. Now, CJ may be right. A lot of lawyers will say, if that potential juror will look me in the eye when I'm talking, that's a juror I can work with. And then gender will play less of a role. But there's no way to answer that, it's sort of an absolute with all jurors, because this is a one-by-one, potential juror by potential juror evaluation. Do they have to question all 300 before they finally choose 12 and 3 alternates? No, I think they're going to do it 50 by 50, and in each group of 50, see how many that they can seat. Now, states do it differently. There are states where the other jurors who are when they get to, let's say, 5, And there are some that have been struck, some that have not been. Sometimes they're held over, even when they bring in another group of 50. But typically, if you're in a group of 50, they're going to run through the whole 50. There will be some that will be struck for cause. There will be maybe some peremptories used by the defense and the prosecution. And then if there are 12 left, they may well, certainly if the defense and prosecution use all the peremptories, then whoever's left is going to be on that jury. Are you allowed to ask something so specific such as, could you put a woman in prison if you knew it would leave her children without either parent? I would say yes. Now, the other, if that's a question from the defense, the prosecutor might object. Question from the prosecutor, the defendant might object. But that's going to run to information with regard to bias. And one of the other things that happens during voir dire is the state and the defense start to make their opening statement during voir dire. You can tell from the questions the direction that the opening statement is going to go. So could you put a woman in prison if you knew it would leave her children without either parent? Would give you some indication of how the defense is going to put in evidence, or if it comes from the state, some indication of, the state's concerns about what jurors might do and where the sympathy might lie. So generally on the voir dire, there's a fair amount of latitude given that, but having said that, that depends on jurisdictions. There's some jurisdictions where lawyers, for example, are not allowed to ask a question at all. The judge asks all the questions, and if a lawyer has a question she wants asked, then she gives it to the judge, and if the judge agrees, the judge will ask the question. Some jurisdictions, the lawyers are asked both sides are allowed to ask questions, but the judge keeps a tight rein on it. Other jurisdictions, there's a lot of latitude given. And, going back to that prior question, which was essentially, can you probe more deeply if it's a serious crime? That would enter into it too, and there is going to be more latitude. Because the one thing the judge and the state do not want in particular is to have prevented the defense from asking questions that on appeal, the defense can say these were relevant, they were probative, and our failure to ask those questions meant we were unable to make a fully informed decision about which potential jurors were seated. Other questions? Or have we exhausted questions? Oh, who decided, this is Little Miss Red Velvet. Who decided on what the questions are, what the criteria is to strike? Well, the for cause criteria, although I think there will be examples of it, are really well understood. It's a murder case and your brother was murdered. That's going to end up being a for-cause strike, because what will be concluded is that sort of information in your background is so potent and so overwhelming that we don't want to risk the possibility that it will color your judgment no matter how much you try not to have it colored. From there, it's more a matter of judgment. It's a matter of whether the state in particular will object to questions that the defense wants to ask, or areas into which the defense wants to inquire. And I say the state because it's the state that runs the risk of the appeal, not the defense. If the defendant is acquitted, that ends it. The state double jeopardy means the state can't try it again. So no matter what is going on, the prosecutor doesn't get another bite of the apple. The appeal is done. The other way around, if the, and so the appealable grounds, the prosecutor wants to be careful that the prosecutor doesn't object, as I said a moment ago, in a way that on appeal, the defense can claim that they were too limited in what they were able to do in voir dire. So it's, as a general rule, it's probably more likely that the state is going to be less active about, objecting to any questions that the defense might ask. And, they may also try both sides if they're going to make an objection to ask the judge if they could approach, so whatever the objection is, it's not heard by the jury, which in itself can go to not prejudice the jury, but lean towards, if you have to make an argument about, this person that question shouldn't be asked because it tends to uncover this and you shouldn't be able to uncover it. There are a lot of tactics in jury voir dire. And I mentioned a while ago, there's a lot of research on impaneling jurors and behavior of jurors. The defense in this case likely did some mock juries just to get a better picture of what kind of juror, what kind of background, even what kinds of arguments would be more persuasive with jurors than other arguments. What backgrounds, gender, age, whatever, will lead to a particular juror being less receptive to an argument. And so they're going to come in with some of that information. Tim Jensen said the other night, and he's absolutely right, they also have 2 other trials that they can look at and the profiles of the jurors who sat in those trials. If, for example, Wendi were tried maybe 5 years ago when her children were young, you might think that in that trial, Georgia, having experienced what happened in Katie McBana's trial with the holdout juror, would be more likely to be reluctant to accede to the seating of a woman who was pregnant or a woman who just had very tiny, small, minor children. Now, of course, it's generalizations. The fact that one juror acted that way doesn't mean that every woman with very small children or every pregnant woman is going to act that way. But you're operating on limited information, and therefore you're going to make your best judgment on the limited information you have because you're not going to have more information. Change of venue ruling still on the table? Yes. The change of venue is only alive, let me say, when it is demonstrated that there is a lot of difficulty seating an impartial jury. Until you try, you can't know that you can't seat an impartial jury. And in law, no matter the question, whatever what the question is, generally speaking, you can't make it in the abstract. You have to be able to show that in a particular case, this issue is relevant. This issue is important. You just can't say, we believe it will be so. And with regard to impaneling a jury in the venue at the place where the crime happened, there's a significant public interest in having that trial held in that venue. The social fabric, as it were, has been ripped by a murder of a fellow citizen in that jurisdiction. And the public there has a right to be part of the process by which the guilt of any particular defendant is adjudicated. So the change of venue, there's a big interest on the side of the community. It's also expensive and inconvenient to move a trial somewhere else. So the rule is clear and I believe absolutely correct. You come and make that argument once you show me that we're having extreme difficulty, getting a jury impaneled. And once you show that, then we're going to go from there. But we're not going to hear the motion until you can make that showing on the record that we see. Do I remember if the jury was allowed to take notes in the other trials? You know what? I don't. So I apologize. I don't. Some jurisdictions permit note-taking, some don't. Jurisdictions where note-taking is permitted, sometimes it's up to the particular judge whether he or she will permit the jurors to take notes or not. There was a time many years ago where note-taking was prohibited everywhere on the theory that the juror who's taking notes is going to be more persuasive in the jury room with other jurors than those who are relying on their memory. even though the juror taking notes may have written it incorrectly. So the notes may be wrong, but the theory was there's too much, we worry that there's going to be too much credence given to the person who wrote something down. Over the years, that has been less and less a concern. And today, I believe most jurisdictions allow jurors to take notes. But as I say, many of them say it's up to the particular judge in a particular trial whether he or she will allow notes to be taken. Will you get to see the jury questionnaire sometime after the jury is impaneled? You have to wait until the verdict. I think you have to wait until the verdict, but that's not something in terms of Florida that I can answer without any question. If there's somebody in the chat who knows it. Jared Ross is answering the other question. Thank you, Jared. He said, you can read what he said. He believed they were able to take notes, but they had to leave their notebooks in the jury room when they left the building. And of course, that would be a sensible thing to do because the jurors are not supposed to talk about what happened. They're not supposed to even talk with each other outside the jury room. And if they so if they take their notes home, the possibility that somebody else may see them, read them, or that they might leave the notes on a subway, on a bus, in an Uber, is just too high. What is my perspective regarding voir dire? Seems a number of high-profile cases have hinged on jury issues in the last few years. Some seems jurors themselves now are at personal risk. What is changing? I think voir dire is extremely important for lawyers. You build a relationship with the jurors. You let the jurors know that you're a person too. You get a feel how they're going to decide. And who the jury is who selected is relevant to what the verdict will be. So it's extremely important. Jury issues come up. One needs to be really careful. The judge needs to be very vigilant about it. In the trial with Charlie, there were issues that were raised in his appeal, saying there were discussions in the jury room, in the room where the potential jurors were waiting to be called, where they were told, don't talk about the case, don't talk about this, and 2 or 3 were overheard talking about the case. And so under the judge's control, we don't know what's going to happen in the appeal in Charlie's case with regard to that. My guess is it won't be successful, but this time around, Judge Everett said no talking while you're waiting to be called in to be interviewed. No talking unless you're impaneled or you're discharged. Bring a book. We're going to have magazines for you. And I'm putting more bailiffs in that room to make sure my orders are being followed. Asked if jurors can be questioned about faith, i.e. Jewish jurors, given it's kind of an issue in this case. That's much more difficult, because I said before that protected classes, and certainly your religion or your not having a particular faith is a protection to you. On the other hand, the question about are you religious or not may be relevant. I think where the balance would be struck is you might be able to ask questions more generally than are you Jewish? Are you an observant Jewish person who follows kosher rules, or are you socially Jewish, as compared to any questions that compared to questions such as do you follow a faith, or even more generally, maybe more pointedly, do you have any reason in your background that you might believe somebody who is an observant in a religion more than you might believe someone who is not? But you will find, if those questions are asked, you'll find out right away how far the judge is going to permit questions like that to go. And I suspect both the prosecution and the state will be really careful about it, because they can also offend potential jurors. And not simply the potential juror who might be asked the question, but other potential jurors who hear the question being asked. Can they sequester the jury after the trial starts? Yes, but Judge Everett has already said this jury is not being sequestered. And for sequestering, just in case somebody has not followed trials in the past and may not know, sequestering means the jurors are not permitted to go home at night or on weekends until after a verdict. And that's an extraordinary thing to do to jurors, and it's only done in rare cases. Can you can you ask a juror if they're a Dallas Cowboys fan? Probably yes. There might be an objection that it's not relevant to anything, but it doesn't sound like it's harmful either way, at least on the facts of this case as I know them and as what I know about the Dallas Cowboys. So I don't know that I will say that I heard when I was driving earlier, I heard the COE talk about the reporter from the Tallahassee Democrat posting on his X account because he's in the courtroom and he's able to at least observe what the potential jurors look like. And I think he's been able to hear some of the questions at least. And the CEO urged people to go over to that Twitter account to get more, sort of as you go information than you can get simply by listening here. And so I will repeat that. And his name is Jeff B. Burbidge. I'm not quite sure. If Jared's still in the chat, I'm sure he will know. What?
Jeff Burlew.
Burlew, that's right. I knew
Yes.
it wasn't Burbidge. I'm becoming British and thinking of, an old actor in Shakespeare's time. I'm becoming British and also irrelevant here. But yeah.
Actually, Joe, now that you're here, I just wanted to pull these photos up because I don't know if you saw these. These were the images that were shared earlier. And I guess this is what they're doing, behind cameras that we can't see. And this was sort of the setup that they shared.
Right. And you can see that they're on laptops. The state had access to the jury pool and might have run records checks and other things by now. I'm not sure that the defense has equal access to that until they start. But what they're doing now, and imagine yourself as a lawyer on either side, you've got to keep track of what these potential jurors are saying. The ones who are struck for cause, the ones who have an excuse that the judge is going to recognize, such as my classes start tomorrow and I can't afford to lose the first 2 weeks of a semester. You don't have to worry about, they're gone. But now you're going to have a lot of jurors who are going to be answering questions, and you've got to keep track of who's saying what. And that may sound to a lot of you as an easy task. But remember, you're also asking questions. You're tracking what the judge may be asking. You're tracking what your adversary's lawyers are asking and trying to keep notes. It's not as easy as it sounds. But that's what they're trying to do. So it may well be that when you have two lawyers, one is keeping track of what the answers are and filling it out, and they typically will have a chart. So we'll have juror number 1 or juror number 15, and they'll put down the pertinent information that they're getting from each, and then they'll be able to consult when they decide what they're doing about strikes. Yeah, I saw one of these. I didn't see all of them.
And Joe, Donna's obviously taking a lot of notes. She looks very engaged and involved, or at least, listening intently. How involved can she be in terms of the questioning? Is she allowed to lean over and ask her defense attorneys questions or suggest anything?
She is, but her lawyers are probably going to say, we're having enough trouble following and everything. You can't distract us this way. But sure, it's her trial. And she's the one who's going to go to prison for the rest of her life if she's convicted. So she has a right to talk to them. On the other hand, the jury selection process is one of those areas where the lawyers are permitted more sway in making judgments because this falls on the lawyer expertise side. And I would like to say, if Joel is listening, I told him she would not have her hair in a bun because she had that new, that flip style, and it didn't look long enough. And I admit error, because she clearly has it in something in the back. Now, whether it's a little ponytail or what, little ponytail. So, she is pulled back. Notice she doesn't seem to have makeup on, and she's dressed very demurely. No flash, no, doesn't look like anything fancy or any, that the clothing cost a lot of money. So she certainly, that gives you some clue as to how she's going to present herself and what they expect her to say and what the defense will be. It supports the idea that the defense will be, I didn't know what was going on. I believe my son. I'm a poor little old, lady who's never had to deal with any of this. And I trust him. He's the smart one in the family. He's the one on whose judgment I rely, and et cetera, et cetera. She's dressed to make that defense.
And Joe, I'm just going to pull this one up. This is from yesterday, but it did catch a lot of people's attention. This is not Donna, but this is Harvey.
Yeah.
People keep asking about Harvey and whether he's there. He was there yesterday. He was there today. I'm not sure if he ended up staying for all of jury selection, since it's obviously been a long day. But what about Harvey in all of this? Is he allowed to, be consulting with defense attorneys through all of this, or is he just sort of a bystander who's watching his wife go on trial?
I think he's like you or I. He's a bystander. He's not a lawyer. He's not the one being charged. And the fact that he's a spouse shouldn't give him any more right or privilege to participate than you would have or I would have. I don't know. I saw this photo last night. I don't know whether there are potential jurors in the room, but the clowning is inappropriate. I was told, or I read something last night, that he was doing that when he caught a photographer from I guess it was the Tallahassee Democrat, taking his picture. But, one would say that's not the behavior of a spouse at a trial when the other spouse is on a trial for murder one and may spend the rest of her life in prison. This photo, these are the two I saw last night. If there were more, I didn't see them. And I heard someone say they're looking at each other and that she's teary-eyed while she's looking at him. And I don't know why his arms are in the air that way, but, maybe he's trying to protect himself from the camera. Who knows? I don't know why he's doing it. I don't know why he's doing anything except sitting there with his arms at his side, looking like a responsible, caring spouse who's there to support his wife.
Yeah, I find these photos to be interesting, especially since last time it appeared he really didn't want to be photographed. And now, I don't know. It looks like it's changed a little.
Yeah, now he's calling attention to himself. Right.
Exactly. I do want to let everyone know that Joel is on the way to Tallahassee, and he's expected to be there before he's live, which is supposed to be at 7 p.m. Eastern time. So he is going to have a live show tonight discussing jury selection, what's going on today, and what to expect tomorrow. And then tomorrow, Joel will also be in court all day. So while we haven't gotten all of the details that maybe we've wanted today, I'm sure we'll get all of that tomorrow, as Joel is sending us notes and updates and tweeting all day.
And I heard him say that the show tonight will be jury consultants.
Yes. He's expected to have at least one or two jury consultants that really understand,
right,
how this all works. And I mean, I'm not saying it's a game, but obviously there are many different pieces of this.
Right. And so anybody who's here in the chat who has the time, I would urge you to watch that, because some of the questions you're asking me could be also asked of the jury consultants. These are the people who advise the lawyers about what to look for, what not to look for, what things seem to work and what not. I would say, when we were talking about, would you go for women? Would you go for men? Would you go for old or young? And I said there are a lot of characteristics. One of them is, do you think you're looking at jurors that follow rules, or jurors who like to be off on their own, making their own judgments? The rule followers tend to be, now all of this is a generalization, but the rule followers tend to be good state jurors because they'll hear the jury instructions and they'll follow the jury instructions, and they won't go off on what lawyers call a frolic and detour, thinking they know better.
And Jo, I know that working in media, we always had media consultants, and all of us were always saying that we didn't think the media consultants always had the best ideas. What about these juror consultants? Do you think that they're really effective?
I've heard a lot of trial lawyers say, and I tend to believe them, that a good experienced trial lawyer can do, who knows the community, can do as well as a jury consultant. That the difference is that good trial lawyer cannot pull apart why he thinks a potential juror is a good defense juror or a bad defense juror. He cannot pull it apart and give you a kind of a schematic, whereas the jury consultant can do A, B, C, D, E, and this is why this type juror is somebody you want. But if you've got the money and you're going to go on your own instincts, it doesn't hurt to have more information. It's ultimately the lawyer's call in consultation with the client, whether the information the jury consultant is telling you is something you want to follow against your own instincts about what you should do. But so I think on the margin, they can help. And for lawyers who have not done a lot of trials, maybe they can be more helpful. And good jury consultants are going to be better than those who are mediocre. And, jury consultants, are behavioralists in terms of looking at behavior, looking at body cues and everything else. Some of them have not done many consultations in criminal juries. And so what they know may not be sufficiently relevant or poignant when you have a criminal jury. I think in Charlie's trial, there was somebody who the jury consultant evidently advised could be seated on defense, and I don't think no trial lawyer that I know, let me say, and I don't know the world obviously, but no trial lawyer who's done a lot of trials that I know would have let that potential juror be seated. He had some sort of law enforcement background. And typically on the defense side, you do not want anybody with a law enforcement background to sit on the jury.
And Jo, the chat says that they'll ask you questions all night long if you want to stay, but we respect your time and we know that you're also a very busy person. So if you want to hop off, you're welcome to. If you want to continue to stay on, you're welcome to. The stream is going to stay up until court is in recess for the day, which is probably, I'd say, another 45 minutes or so.
Yeah, well, if there are questions, I haven't been seeing them. I can put my phone on and see if I can see them. I can stay on for probably another 40 or 45 minutes. Today is Kids Night on Broadway, and I'm taking a niece in to see a show, but we won't leave until a little after 5, so I can certainly stay on for another half hour or 40 minutes if people are interested. I mean, I don't want to bore anybody, so.
No, you're welcome to stay, and people will always take your perspective and your expertise. We love to hear from you. Jo, you do have a question here. This is from SP74. She's actually local in Tallahassee. And she says, will the lawyers know the jurors' names and can they look up their social media?
They will know the jurors' names, yes.
And do they go as far as looking up social media?
Well, I would think yes. I mean, they're not, if the social media is public to you and to me, then so should a lawyer be able to look up and see what the lawyer can find out about that individual. I mean, to some extent, when you're called to jury duty, your traditional, right of privacy, slips a little because each side has to assure that what you say is truthful and has to also know enough about you to make an informed judgment. It's not like going into a grocery store or into a theater or anywhere else where they're not entitled to know what my name is. They're not entitled to know, what I do for a living, none of that, because it's not relevant to their job. But some of that information is relevant to making an informed judgment about who's going to sit on a jury.
And today, as they're going through all of the process, and obviously I know it's day one, they're just beginning, they're just, at the first step of this. What do you think is the biggest challenge for both the defense and the prosecutors?
Challenge in sitting a jury?
Yeah, just in, in trying to figure people out.
Well, I would think, one big challenge is trying to get a read on whether the information that's being provided is full and truthful and accurate. Some people do not want to sit on a jury, and so they will say things, I won't be able to give you an impartial view, and they're not telling the truth. That's not as harmful than the person who dearly wants to sit on the jury and is trying to scope out what she can say to assure she gets to sit on the jury. That person is typically not a juror that either the state or the defense wants. So that's so that's one major goal they have. After that, the tough thing is juggling all the information and making a call. And this is the kind of part of a trial or life in general, where you're making really important decisions on not full information, because you can't get full information, and you're just going with your best judgment. And that's always it's the best we can do in this life, but it's always, a little uncomfortable that that's where you are. And I think most lawyers trying to select jurors to serve on a jury feel that way. It's a momentous decision that may affect everything else, and you can't go look it up, you can't go brief it, you can't find a case that's going to say this lawyer with this juror with this background is who you want. You have to make a judgment call, and we can be very confident and feel that our judgment is very good, but it's not fail safe. So that's what I would say is the place where I think lawyers find the most difficulty in picking a juror. On the other hand, for many, many lawyers, and I think Georgia would be one of them, probably also Sarah Dugan, it's a chance to interact and engage with people. And if you're naturally able to do that, then it's another opportunity to do that. So it becomes a challenge, certainly, but it also becomes, in some ways, a fine experience, an enjoyable experience, even with all the tension. And there is a lot of tension at trials. And any trial lawyer who tells you, gee, it's easy, I don't worry about it, I don't kvetch afterwards, I should have asked this question, I should have done it this way, I don't think is being entirely truthful. Okay, will the jurors be able to hear the phone call that is Donna making a plan to flee to Vietnam and identify the other voices in the call? Yes. That's Donna's admission. The judge already determined that the information about the phone call is admissible, and the actual phone call is better evidence than somebody reporting what was said, more effective with the jury. Now, there may be something on the phone call itself that the judge will rule as the evidence goes in is inadmissible, but the phone call itself, I fully expect you will hear the phone conversation or part of it, just as I fully expect that the jury is going to see the arrest at the airport when Donna and Harvey were attempting to get on a plane and go to Vietnam. So,
Joe,
why
I
would
just
they
want
only
to
have...
hop in here really quickly. I start a few comments that I'm going to have Space Coast pull up for you.
Okay.
I actually have to race to get Vita because it's her first day of middle school.
Oh, good luck.
Yeah, thank you. She's on the bus for the first time, so I want to be early and be there for her. But I'm going to be watching from my phone. But Space Coast is here behind the scenes, and he'll pop up a few questions for you. And then whenever you have to go,
that's great.
Feel free to just hop off, and we'll keep the stream up until the court ends.
Okay, thank you.
Thank you so much, Joe. We appreciate you.
So
All
long.
Bye.
All right. Why would they only have 3 alternates with the start of flu season? I don't have a good answer to that. Because if you run out of alternates, you will have a problem. But I'm, what they call a belt and suspenders person. I don't want to rely on either. I want to be overcautious, and I probably would have had more alternates. On the other hand, you only have so many potential jurors in Tallahassee, and there are other trials going on. So if every judge in every case was overcautious, you know, you have more risk that you're going to run out of people in the pool, because not only are there only so many, but, you know, you get a grace period after you've been called on a jury or called to potentially serve on a jury before you can be called again. Any light you can shed? I lost the question, so I can't answer it. Can you, whoever had that question, if you're still in the chat, you want to put it up again? Because I didn't get to read it before it disappeared. And I'm not able, I'm going to try to find this on my phone, but right now I don't have this pulled up. Oh, here we go. Thank you. Any light you can shed on planted or compromised jurors? Planted jurors, I don't know what that means. If you mean, gee, I'm just not sure what that means. I don't want to speculate. I apologize, Julie, but I'm not sure what you want me to answer there. Sorry. I'm just not doing well right now. Anything else? Let me see if I can pull up my stream, if I can get there. What was the decision yesterday about the jail informant? So far as I know, there's no decision yet. And I do believe firmly that the judge needs to make that decision before the trial actually starts, because it's relevant to whether the state can mention something about the jail informants. That is what seems to have been a statement Donna made to Bernhardt, the jail informant at issue, at the jailhouse. That particular conversation, and the defense may also want to be able to refer to it. And if there is a decision that's not made, then neither side can really refer to it. And I don't think that would be fair to either. So I do think the judge will decide between now and whenever, Friday. I'm assuming Friday is when opening statements will be, or Thursday afternoon. I said on STS, what's today? Today is Tuesday. Was it last night? Must have been last night. That I think that the issue with regard to the jail informant is really a pretty substantial issue that the defense is raising. Let me say before I talk about that, the Bernhardt, the jail informer, has a couple of places where she has evidence relevant to the criminal prosecution. She is also the individual at the jail that my best guess is has talked to or knew Magbanowa when Magbanowa was at the jail, was now considered by Donna her second daughter. So Donna confided in her at the jail. And it appears as though Donna may have given Bernhardt a script advising her as to what to say to undermine the state's case. Now, whether what the script was about is, saying that Magbanowa said something that would undermine Magbanowa's testimony, or some other version of it, we don't know. But that's what it looks like Bernhardt would be testifying to. It does not appear that the second issue with regard to the jail informer has anything to do with that, with the script and whatever the initial encounter, the initial evidence is that Bernhardt can give. This one is Bernhardt had information from Donna. We don't know what it is. Bernhardt went to one of the law enforcement investigators saying, I've got this information. And he told her, you can go back and listen, but don't initiate anything. Don't ask any questions, but act normal. Now, translated, what that means is he told her, you can still talk to Donna. If she's giving you admissions or saying things that are incriminating, you can listen. You don't have to walk away. You can't ask her about them. You can't probe what she's saying. But on the other hand, you can't just stand there like, like a dead fish. I guess a dead fish wouldn't stand. Sorry. You can't stand there like a pole in the ground, because that would be suspicious. So you've got to at least be able to say, that's interesting. I didn't know that, to continue your end of the conversation. That appears to be what the argument is from the motion that had more blackouts than, than anything I've seen in a long time. The law there is, after the Sixth Amendment right to a lawyer has attached. Now, everybody knows about the Miranda right and what you can or cannot do with regard to Miranda. But there's also a right to a lawyer under the Sixth Amendment. That happens at least by the time a defendant is indicted. So when Donna is in jail, she's been indicted, the Sixth Amendment right has attached to her. That in general means the police cannot go up to Donna anymore and initiate a conversation with her about the crime. Now, the guard at the jail can come by and say, what do you want for dinner? That's not initiating a conversation about the crime. But the guard cannot go up to Donna and say, so did you do it? And get an answer, that might be incriminating. So you cannot initiate. It has to be up to the defendant to initiate, or there has to be a lawyer there. Now, notice how murky that can be. Take a case in which Donna says to one of the guards, they're walking to the courthouse, I'm really worried about this case. And the guard says, well, I'm sorry to hear it. And she says, what will happen to me? And the guard says, well, gee, I don't know. And she says, well, I'm being charged for first-degree murder. What happens? And the guard says, well, if you did it, then this will happen. And that conversation goes back and forth. That's tricky ground for the state, because at some point, an appellate court might say, aha, at point A, it was okay. At point B, it was okay. At point C, it was okay. But at point D, now the state overreached. And at that point, then it's a Sixth Amendment violation. Anything from that point on is then inadmissible. So that's the place where this argument at the in-camera hearing yesterday was focused, I'm sure. What I gave you as a description of what happened comes from the defense motion. I have no idea what the state had to say about it. The state may have a very different version of what occurred, what was said, who said it, and what the statements were before or after. Now, I know I'm talking a lot, but this is a complicated area. The other part of this that makes it difficult is it's a he said or she said in this case, because Bernhardt is saying, I didn't ask any questions. Donna will say, yes, she did. And there's no, tape, we don't think, that's going to confirm one way or the other. So it's also a credibility issue. Now, there was another person in the jail, Easterbrook. I don't think I've got the name right. But anyway, another person who overheard, she claims, the conversation conversations between Bernhardt and Donna. That informant said, Bernhardt didn't just stand there and listen politely. Bernhardt asked questions, and it was obvious from the questions that she was soliciting information about the crime. Now, if that recitation of what that second informer said is accurate, and if what the second informer said is accurate, then there's a Sixth Amendment violation. But, we don't know what the facts are here. I said last night that this is a really tricky area, and were I the state, I would think long and hard about using the information if it's anywhere close to what the defense claims, even if the judge says it's admissible, because it's going to be a lurking little time bomb that can be raised on appeal if Donna's convicted. So anyway, that's my Leo Wren, that's my description of what happened was the decision made, plus the background here for anybody who might not have known what was going on. And I assume a lot of you did. So for those of you who already knew all that, I apologize for telling you what you already heard, but there may be some new people here listening to the case for the first time and won't have a clue as to what that question was about without a lot more information. So, will we know if there's progress on picking a jury versus relocation? At some point, we're going to know numbers as to how many are being seated and how many they've actually talked to. If anybody's in the courtroom watching, they're going to have a better handle on whether any were selected, how many they actually talked to. Certainly the Tallahassee Democrat and Jeff Burley, who's there, will be able to give a good report to the extent it's an open court as to what happened. But certainly we're going to get some information, if not today, tomorrow.
Thursday, 81.
Okay, anything else, or have we, and I haven't been, I'm trying to look and find the chat on my phone, but I haven't gotten to it yet. So I keep looking for it, but I haven't. Okay, let's see. Now I do have it up, and I'll see if I see any questions. Let's see. I don't see any here. If you put a Q or something, I'd be able to find something, but I don't look, I'm finding any questions. If you have a question and you're here and you already raised it once, since I'm looking and not finding them at the moment, put it in again, because I would hate to, since we have a little time, if there are questions, I'd be happy to answer them to the extent I'm able. And I see someone in here, and I lost her name, so I apologize, saying better to have more information in advance on the trial or not. And I agree, which is why I'm happy to stay and answer some questions. So Christine, what would a delay be if they can't seat? Okay, if they cannot seat a jury and they have to change venue, there will be a delay of, I would guess, at least 2 weeks, maybe longer, because they're going to have to move the court personnel. They're going to have to decide what venue. There has to be an open courtroom there because their trial's being, conducted in other counties also. The delay will mean that the subpoenas that went out for witnesses are not going to be timely anymore. You send a subpoena to me and I was supposed to be ready to testify Monday or Tuesday. Now there's a change of venue, so it's going to be 2 weeks from now. There are going to be issues with schedules of at least the witnesses who are not law enforcement as to whether they can make it. So all that's going to have to be rejiggered. So I would guess, and this is a guess, it would be, maybe 2 weeks before they'd get that, they'd have all that straightened out before they could go again. So when does the evidence allowed in or kept out occur? Well, if it's a motion in limine, which is my, if I'm a lawyer, I do a motion in limine saying, I know this is inadmissible, so judge, keep it out now. So we don't have to worry about during the trial. My objection, keep it out now. Some motions in limine are granted. Some of them, many of them, the judge says, well, I can't answer until I know what exactly the testimony is, and then you can make the motion again. As an example of something that was agreed to, but it's in some ways a silly example because of course it was going to be agreed to. The defense wanted a motion saying that 2 of the law enforcement people could not give an opinion as to whether Donna was guilty. Now that's an obvious one. They cannot give an opinion as to whether Donna was guilty. That clearly you can do ahead of time, although it's in some ways a useless motion because it can't be done, it won't be done. But that's an example. Other things like, the argument yesterday about whether the defense can ask Wendi Adelson other questions that are not subject to her privilege against self-incrimination. And her lawyer moved to quash the defense subpoena, and the judge quashed the subpoena. But what's sitting there is the defense may say, yeah, she's got a Fifth Amendment privilege about a lot of things, but she doesn't have one about whether she's her mother's daughter. And where we don't want to ask a question like that, we have every right to ask a question like that. That one, if the defense can make what's known as a proffer at the time, and in fact, I think they should have done it yesterday. A proffer is my saying, here's what I think the prosecutor is going to do. Here are the questions I want to ask. I'm telling you specifically on the facts, this is what I want to do. And now you can rule. Now, I may not get everything. I may not predict everything that's going to happen, but to the extent I can give you concrete, firm, clear information about what I want to do, we shouldn't have to wait. You should be able to tell me that I'm going to be able to do it or not do it before we get to trial. A lot of it, the defense or the state can't say until the evidence starts coming in. And at that point, there will be a sidebar if there's an objection. Sidebar, because if it's inadmissible, the jury should never hear it. And the cleaner way to do it, the better way to do it, is to do it outside the presence of the jury, rather than have the jury hear something and then the judge says to them, you know what you just heard? Forget it, because it's not relevant to anything. So anything else? Here's one. Oh, I see the questions. I answered that. Oh, okay. Leo Wren, what do I find to be the most fascinating aspect of this case, both as a law professor and as a human being? Well, taking the latter first, probably what you find is fascinating, that is how a family can disintegrate before our eyes, and how a family can be so interdependent and so, like an ant colony, that they're unable to act independently, and that they can decide that the way to handle an issue such as custody is to just murder the father. I mean, that just it just seems to me to be extraordinary in terms of an illustration of human nature. Just extraordinary. On the law, I think for me, what will be the most fascinating piece of this is if Wendi is prosecuted and the state will have to go through a hearing, which, by the way, we won't hear. Probably not him. I'm trying to think if there would be part of it we'd hear. I think a lot of it will be in camera with regard to the use immunity privilege and what evidence can come in that's independent of the privilege. That's a very complex area. The privilege is extremely important, and the use derivative use area can be really hard to get a handle on or get your hands around. The law is clear, but for those of you still on the chat who are lawyers, you know this already. Law is often clear. It's the facts and how the law applies to them that makes it difficult. The law on use derivative use immunity is really clear, and the question comes up quite a bit. So I'm going to apologize to those of you who know this, and we're going to be hearing it for maybe the 60th time from somebody. But you and I and everybody else has a privilege under the Fifth Amendment not to be forced to incriminate ourselves. And forced means the state says you must give this information. Have an absolute right to say, no, I won't. I don't have to. You can't make me. Early on, the Supreme Court said, well, and it's also, let me back up. Sorry for taking the side step first. The Fifth Amendment privilege only refers to criminal prosecution or being subject to criminal penalties. What's often misunderstood about the privilege is you can raise it anywhere. I can be in a civil trial. I can be in a hearing in front of the Congress. It doesn't matter where I raise the privilege. What matters is I say, my answering this question may subject me to a criminal prosecution, and therefore I don't have to answer it. Okay, so let's go back now. The Supreme Court relatively early on said, okay, we agree. But if a defendant is given what's called transactional immunity, meaning the defendant or the individual will never be prosecuted for the crime we're making her testify about, then there is no prospect of self-incrimination because the person can never be prosecuted, and therefore forcing that individual to give the information doesn't violate the Fifth Amendment privilege. So take Wendy's case. Let's say she's involved in the conspiracy to murder. With transactional immunity, if that's what she was given, she could be put on the stand and she could say, yeah, I was involved with it. I agreed. I told them when Dan was going to be out of town. I went and checked the day of to make sure that it happened. I let my brother know. She could, under transactional immunity, she could never be prosecuted for the conspiracy to commit murder. Never. Wouldn't matter that they had enough evidence independent because Charlie came forward and said the same thing. It wouldn't matter that they found a note buried in the sand by who knows who that says the same thing. She can never be prosecuted. Then you fast forward a number of years and a state said, we don't want to give transactional immunity. We want to say that we can force a person to testify and give evidence that is incriminating as long as we guarantee we will not use anything she says. And we also guarantee that we will not use anything that we found out only because of something we forced her to say. So it's derivative use immunity. And the Supreme Court said, well, that's enough, because it would be as though she never spoke at all if she speaks and says, yeah, I was involved in the conspiracy, and you can't use that statement ever against her. So it's like she never said it. You can't use anything you found out because of what she said. So again, it's like she never said it. But if you find it another way, if an eyewitness says, you know, I was sitting in a cubicle in a restaurant right next to her, and I heard her tell her mother, the murder is done, thank God he's dead, that person can testify because it wasn't that statement that Wendi made to her mother, had it happened, was not forced by the state. And so the court said, you know, that would be the case even if she was never given derivative use immunity. In other words, she's mute, never says anything to the state, but she's in that banquette or cubicle or whatever it is and is overheard. You can use it there. So the derivative use immunity is not affecting her Fifth Amendment privilege at all. That's the black letter law. The black letter law, what lawyers mean is it's the clear law, tells you what the rule is, clear. Apply to the facts, it becomes a lot murkier. Anything that Wendi said before she was given the immunity is easy. So clearly, easy, the first interview with Isom. She wasn't forced to talk to him. She wasn't given immunity about it. No question it's admissible. Anything that, but the rule also says that anything that the law enforcement found another way is admissible. That's harder because now the state is going to have to show that it indeed found it another way and it was independent of anything she said. Or at the very least, they inevitably would have found it another way independent of what she said. And the case that set forth the law here probably gives the easiest example of that. A defendant in violation of his Sixth Amendment rights gave a statement and he said, I've left the child on the side of the road here, and I left the clothes there, and I left something else another place. All of that is his statement. All of it is admissible. And the police, I'm going to play with the facts now, so anybody who knows this case I'm playing with the facts to make it a little clearer to talk about. So if they found the clothes, or they found the body, or they found, whatever else came from the defendant, Sixth Amendment violation, they can never use it. At the same time, the state said we were doing a yard by yard grid of the area in which we think the murder happened. And in doing that grid, we would inevitably have come across the body and where the clothes were. And we can show you how we were doing where we'd have gotten there. We never finished our grid work because he told us where the body was. We admit that there was that violation. He told us we can't use the body from anything he said, but we can show you we were doing it anyway. That's inevitably would have found the body anyway. But it becomes, in terms of showing the facts, can get pretty tricky. And the judge is going to do whatever the judge can do. He's going to lean heavily in favor of protecting the defendant's privilege. Now, another part of it is the defendant with derivative use immunity has to testify truthfully and has to testify fully. And if the witness, if the witness either doesn't testify fully or doesn't testify truthfully, then the promise that we won't use anything you said against you falls apart because the witness didn't live up to her side of the bargain. So the promise is extinguished. So the state has the opportunity to show that in this case, it would be Wendi, lied under oath with respect to something material. That means if she said, gee, it happened, I was walking down the street on June 3rd and I was wearing brown shoes. And in fact, she lied and the shoes were white. That doesn't breach the privilege because whether the shoes were brown or whether the shoes were white, it's just not material. So it's got to be a material something. Showing that a witness on the stand actually lied, that is, with knowledge of the facts, deliberately told an untruth, is also not always easy. And if you listen to Wendi's, if you have time and you're going to go listen to Wendi's testimony from either or three of the prior trials, or listen to her on the stand this time, she often says, I don't remember, but what you said sounds right, or that's probably the way it happened, or I'm guessing that that's true. Those are not fully affirmative statements. It's pretty hard to show she lied if she said, I'm guessing, I think it's true, that sounds right. I don't remember clearly, but that might be the case. None of those are the kind of statement where you're going to be able to say she deliberately lied. So that's where the derivative use immunity comes in. To get back to, and if you think I forgot what the original question was, let me show you that I didn't. The original question was, what would I find on the legal side the most fascinating? And should Wendi be prosecuted? That's what I think is going to be very fascinating. So are there other questions in here? Trying to see. I'm not sure. Here's another one. Let's see. Now I got to that already. Let's see. Answered that one. Okay. Hypothetically, if Wendi were arrested during the trial, could the defense argue for a mistrial because it could potentially taint the jury if they found out? Could be. They wouldn't. There's no way they're going to arrest her during the trial. There's no way. Because of any, the last thing the state wants to do is do anything that could potentially raise an appealable issue. It isn't going to happen. So it's a good question, and it's a good question. And the answer is it just won't happen. Julia Nielsen wants to know if there's a chance of a plea deal now. I would have said there was no chance of a plea deal before, so I certainly don't think there's a chance of a plea deal now. I guess that's all I'll say about it. Okay. How guilty does it make Wendi look to not want to testify to support her mother? Doesn't that say she has something to hide? Well, the jury will never know that she didn't testify to support her mother, so it can't prejudice this jury that's impaneled. You know, I would say, you know, you could say easily, gee, first of all, you can't assert the privilege, and then unless you can show a good faith basis for saying something I say might tend to incriminate me. So you just can't go willy-nilly to a judge and say, you can't subpoena me because I have a Fifth Amendment privilege. You have to have a good faith belief, and if the judge requests, you're going to have to demonstrate in camera the basis of that belief. So, you know, a lot of assertions of the privilege are going to be that far, and certainly you can say, gee, that means maybe something happened. But it doesn't necessarily mean that somebody is guilty. It may mean that there's enough evidence that the law enforcement might believe so, the prosecutor might believe so, and you have a right to say, I'm going to put the state to its proofs. I'm not going to help them find something, even if you're factually innocent. You're not necessarily going to want to provide information that may look like you might have done something. So you have a perfect right to stand on the privilege and protect your rights. And however frustrating it may be, you know, that's why we have a Bill of Rights. The Bill of Rights, forgive me for those of you who don't want to hear a little soapbox speech, just, you know, don't listen, because I feel compelled to do this. We have a Bill of Rights. You know, we're entitled to assert. And often Bill of Rights protections don't protect people we like, that we're sympathetic to. They protect murderers. First Amendment protects really people who make, you know, terrible speech about others, who act, you know, in really terrible ways. You know, somebody you would never invite to your home for dinner or, you know, anything. But if we don't protect it for, you know, people who are the least worthy on an ethical, moral basis, we have undercut the right. You know, to put it another way, you don't need First Amendment protection if you say, gee, I love the government. Nobody's going to ever go after you if you say that. But if you say, gee, I hate this administration, et cetera, et cetera, et cetera, you may need First Amendment protection to protect you from the government coming after you. And that's the same thing with the rights that relate to criminal prosecutions. We made a judgment in many respects 250 years ago that our society is going to operate to treat defendants in criminal cases
85.
As though they're factually innocent until the prosecution can show beyond a reasonable doubt that they're guilty. And we're going to give them certain constitutional protections in aid of their defense. And so the privilege against self-incrimination is one of them. So yeah, you know, in the street, you know, you and I looking at it saying, why would she assert if she's asserting the privilege, she must have something to hide. And, you know, that may well be true, but there are also going to be cases where it probably isn't true, but there is something that an individual is afraid law enforcement or the prosecutor may think shows that they're involved. All right, let's see I'm off the soapbox now, so, and I don't know how to tell you that, because if you weren't listening to me on the soapbox, you're not going to know that I'm now off the soapbox. I should have said I'd raise a pinky or something so that you could come back in. Let's see if there's anything else. Here's another one. If I were on the defense team, what questions would I ask to get an idea whether they are favorable to the grandmotherly aspect of the case? You know, you would ask questions that would explore, you know, do you have, you know, an elderly relative? Do you have a neighbor who's a little older? Have you found that that neighbor needs more help than others do? I mean, that sort of things. It's not, I think anybody in this chat, given about, you know, even 10 minutes thought, could come up with a number of a list of questions which would go towards demonstrating if somebody's got an unusual sympathy or unusual inclination to believe that someone who is older is likely to trust and follow, a son or a daughter, no matter how silly the story sounds. But, on voir dire, asking those questions, I don't think I said this before. You can try to preview your case in general terms, but you can't start asking things that are very specific to your case, whether state or prosecution, in voir dire. It's got to be general. So, do you have a neighbor that needs more help? Not, would you believe a grandmother who said, my son told me, or a mother who said, my son told me this happened, and even though it was silly, I believed him. That's getting too close to the particular facts. Will Donna have a say in juries? This one I think I did before, so I won't do that again. Okay. Can the state impeach any of Wendy's testimony if she tries to lie on the stand? The state is calling Wendi as a witness, and you typically can't impeach your own witness unless you can have the witness declared as hostile. If Wendi were to testify for her mother, which she's not going to do, the state would certainly be able to impeach her testimony given on her mother's behalf. If Wendi is prosecuted and takes the stand at her trial, the state can impeach based on prior statements, even if there is not enough evidence that the prior statements became deliberate lies that avoid the privilege. Let me see if I can put that another way. Wendi does the drive on Trescott. I didn't turn, I did turn, I saw the tape from the road. I mean, all the different versions she gave. The state would be able to impeach and say, didn't you say this time? Didn't you say this that time? To affect her credibility in Donna's trial. Oh no, I'm sorry, in her trial. But the fact that the state can impeach doesn't mean that she has necessarily waived her ability to assert the immunity, because all those prior versions, none of them may be provable as a lie on her part. In other words, an intentional decision to deceive. Now, I'm sure some people in the chat are going to say, of course, it's obvious, but there are a lot of things obvious in life that you can't prove to the satisfaction of a judge in terms of admissibility of evidence or to the satisfaction of a jury. Okay. Question is, do I think the state does not arrest Wendi because they don't have enough evidence? Will it ever happen? I've said before, I think there is enough evidence, but it's a close call, and a jury would have to draw all the inferences in favor of the state and not an innocent explanation for the same conduct. And I gave one example before. Let me try another one. The broken TV, as maybe her establishing an alibi. Now, maybe that virtually every juror would say, who is going to call a TV repairman in to look at a TV with a broken screen and think it's worth repairing as compared to buying another TV? So we don't buy it. In other words, the broken TV by itself doesn't prove she was trying to establish an alibi. But the other part, why would anybody do that? I'm going to draw that inference, and most jurors might, maybe almost all. But there might be a juror who will look at Wendi and the other evidence in the case. She couldn't drive to Tallahassee on her own. Her parents had to to Miami on her own. Her parents had to drive up to Tallahassee, pick her up, drive her to Miami, and then drive her back. The evidence that when she was, looking or considering, dates and maybe a potential husband, that her mother looked with her and her mother picked out the person. That evidence for some jurors might be, this is someone who wouldn't even know whether, TV is worth repairing, and would have to call her brother and talk to her brother about it. So that's one example. The jury would have to look at the fact and draw all the inferences in favor of guilt in order to get to a guilty verdict. I think it's possible, but there's only one shot at this. And if there's an acquittal, you can't go back and try it again. So the other part of the question is, if they don't do it now, when? I guess the other answer would be they might wait until Charlie's appeal is over and see if, when he's done and doesn't see any way out, whether then, since I think he's pretty clearly angry with Wendi, or let me say I would be angry with Wendi if I were he, that he might be willing then to give them information that would bolster the case substantially. And so, if they think it's so iffy about the jury drawing all the right inferences, that would be a reason to wait at least a while. But I also have said, and I believe this firmly, that I think the prosecutor could, on the evidence, assuming the inferences, make a sincere judgment that there's a reasonable basis to believe a jury would convict beyond a reasonable doubt. And that's what the assessment has to be from the prosecutor, and then go forward. And at some point, this is going to be a fish or cut bait. There's no reasonable likelihood of ever having more information. So if you have a sincere and reasonable belief, my view is you go for it. But let me say, I'm not running the budget in the prosecutor's office in Leon County. I'm not looking at a number of prosecutions that have to be, pursue other murders and other cases. I'm not looking at bringing in all the witnesses again and going through it all again and inconveniencing people and taking up court time and personnel time when the case is going to be possible but difficult. Let's see if there's anything else. I don't see anything else here. I don't want to miss anything because we do have a little while. And as I say, I'm more than happy. And I think the person, and I apologize for who said it, but the person who said nice to get as much information ahead is absolutely right. Because then when you hear something, you have a sort of a context in which to put it. And by the way, that's exactly the argument for why opening statements are so important. Because the opening statement sets the juror's mind. Here's what you're going to hear. So when you hear these pieces of evidence, you know where to put it in the sequence, and you understand why you're hearing somebody testify to a contentious post-divorce proceeding. Otherwise, it's a lot of facts that are coming in, and the jury has to work to figure out why do they relate. So jury opening statements are extremely important, because the lawyer who does a better job of embedding his or her version of the case with the jury has a head start on how the jury is going to hear the evidence. All right, is there anything else here? Not, I hate to keep you while I'm reading, but I don't want to miss any of these questions if I can find them. If anybody has a question, I haven't answered it, and I'm, you're still here. Oh, Rosie wants to know if there's a good law book I can recommend. There are treatises on criminal procedure and on, well, let me back up. The books that we use in law school are called case books. They go through the law generally by looking at cases. They're pretty hard to extract sort of rules of law and principles. Takes a lot more work. And of course, in law school, we do it in class. And the case books are done that way because our job as law professors is to get, we used to call it thinking like a lawyer, is to move students to the point where they can read a case, extract a principle, evaluate precedent. They have to be able to do it on their own. Because if you go to a lawyer, you want a lawyer who can do that, know case book. No list of cases is going to tell you how the particular case that your client brings in will be handled. It's always how the law applies to these particular facts. And what you need to know is how you make that assessment. So case books are not a good place for anybody who wants to learn this law quickly. There are also treatises and what are called horn books that do it in a discursive fashion. They're still can still be pretty complicated. And I'm trying to think if I know one that would be easier. So I'll tell you what, Rosie, if you're really interested, send the question to Joel or to STS. And meanwhile, I will think about it a little and look around, in terms of the books I have and see if I have one that I think might work. Okay. Patricia White says she wasn't a little old lady when this all started. Will the jury know that? Well, the jury will know when Dan Markel was killed. So they'll know the murder was 11 years ago. And she's being prosecuted for paying for it, conspiring to pay for it. So they'll certainly know it's an 11-year process. Oh, so now Little Miss Red Velvet has decided, since I can't answer this right away, to ask Jared Ross what law book he would recommend. So if Jared has an immediate idea, I defer to him, and I'm glad that if he can, that he's able to suggest something right away. Question, would I feel confident prosecuting Wendi with the evidence that's publicly available? I myself, probably not. I wouldn't say I've done a sufficient number of trials to feel confident to manage a murder case like this. I would feel confident to handle the issue as to the extent to which the immunity covers, in terms of a hearing, because that doesn't require, knowing the whole enchilada, having enough experience of the whole enchilada of a case. And I think in a murder one case, you need somebody who's done a number of major felony trials. Is it possible for the Markel family to sue Wendi in a civil action where the preponderance of evidence is less, even if she's never criminally charged? Sure. But there's going to be a statute of limitations on the civil side as to when you can file civilly. And I don't know what it is in Florida, and I don't know if there would be an exception if there's an ongoing criminal case involving the matter, nor do I know whether, if there's an exception, it would cover someone who has never been prosecuted herself. So, the general answer is yes, but there are a lot of caveats to it. What is my favorite Italian dish? It's clearly not relevant to the trial, but I would say probably all the things a person shouldn't eat: pasta and pizza, not pastries. Italians are really not big pastry, although they have them. It's the staples. And I like pasta. I like lentil soup. Yeah. So there you are. Okay, let's see. Little Miss Red Velvet wants to take a class with me. I'm not currently teaching. I had expected to, but I've been traveling too much, so I'm not here for a full term. I've said before, I might think about doing something, sort of online, criminal law, criminal procedure for people who are interested, who don't want to go to law school, who don't need a law degree, who don't want to read a case book, and do it in maybe 4 or 6 or even 8 online sessions. That I think would be fun. I don't know if anybody else would think it was fun. You should know that I didn't have a well, let me say it the other way. I had a reputation of being let me think if I can put a taskmaster in the classroom. I was telling Anise some of my stories today. My students used to have, they tell as alums, tell stories that are just unbelievable about how it was like being in my class. I don't believe it for a second, but it does give them great cocktail party chatter for the rest of their lives, and the stories get bigger and bigger, as the years go by. All right. Do I have any ideas why Wendy's phone was not wiretapped? They may not have had probable cause. You just don't wiretap a phone. You've got to have a basis in evidence. And the evidence typically required to get a wiretap is going to be the judge is going to look more closely than even a search warrant. So, and what you have to show is for a wiretap, that there's a reasonable likelihood, there's probable cause to believe that a crime is committed and that evidence of the crime will be derived by listening to this person's phone. And those of us who sat now through 3 trials can say the likelihood that Wendi said something that would provide evidence in a telephone conversation is probably not high. Now, getting a wiretap against Donna, who's Little Miss Chatterbox, might have been easier given her track record. The state is limited. I mean, there are lots of things one might want to do and evidence one might want to go after, but there are rules as to when you can do it and how you can do it. And again, if you were to, wiretap is a little different, but if I went after evidence against you and I didn't have probable cause, I could never use the evidence. And there might be other consequences that come from my not being able to use the evidence. And plus, it's an extraordinary invasion of privacy. So you do want a high standard on a wiretap. When you know somebody is guilty, it's easy to see it when you think, hey, this person is guilty, so let's do it. But it also affects you or I who haven't done anything. When the standard is low, you open the potential for a wiretap against you too. And I know that sounds, a little Pollyanna and it would never happen to us. But, we write the law to protect not, okay, we're worried about the guilty, but we really write it also to protect people who are factually innocent from overreaching by the government. Okay, I don't see any more questions here. So unless something pops up right away, I think I'm going to call it done. It was great being here. I will be back on Friday to do, the coverage, and I'm looking forward to it, and I look forward to your questions. I might be able to do a little on Thursday, not sure, but tomorrow's blacked out. I won't be able to do anything, I think. So long. I hope I was helpful, and I'm going to sign out now.
It's a new day. My understanding. Here's the thing.